Call this meeting to order. Madam Clerk, will you call roll call?
Member Nee?
Present.
Nee present. Member Washburn?
Here.
Washburn present. Member Pilpel?
Present.
Pilpel present. Member Sims? Sims absent. Member David?
Present.
David present. Member Highland?
Present.
Highland present. Member Oka?
Present.
Oka present. Member Fisher? Fisher absent. And Chair Grant?
Present.
You have a quorum.
Great. At this time, I'd like to go over any agenda changes. There's a couple. First of all, glasses. If we go to item number 6, file number 12055, both parties have asked. Can you guys hear me? Both parties have asked for a continuance until October. My phone will go off. Item number 7, file number 13011. I'm sorry, not 13011. 13016, item number 8. The complainant has withdrawn his complaint. And as far as the election of the chair and vice chair, election of officers, I'd like to hand this over to Attorney Threet to explain that we actually are not able to hold those elections right now. Accordingly to the bylaws, we can schedule an election from the meeting, but we cannot hold it so we need to have an appointment.
Madam Chair,
Yes.
that is an agenda item. I would suggest that we
Okay.
wait until we get to that one, and then we can deal with that.
Okay. Okay. Are there any agenda changes other than the 2 items that I just mentioned?
No.
Member Popel?
Just discussion before we take a motion, if we need to do a motion on.
For the 2
Item
items
6.
that were continued and withdrawn?
Well, if item 8 was withdrawn, then I think we need to take no action on it. But if item 6, if a continuance was requested subsequent to the agenda being posted, then I think we need to act on that request.
Yes, they requested a continuance until October.
Got it. But I think we need to vote on that. I'm just wondering if there's anyone present for item 6, either side? No? Okay. I'm certainly interested when we hear that item for a little discussion at the beginning about why that's within our jurisdiction. I'm not...
For item number 4 or
No,
item
for
number 6?
item number 6. I'm just not entirely convinced about that. So, if we can suggest to the parties that they be prepared to address jurisdiction briefly. I mean, I'm pretty close. I just want to get past it because it seemed to be a court matter. So, but with that, I'm happy to make a motion to continue item 6 to our October meeting.
Second.
It's been moved and seconded. I'd like to open up to any discussion from the members of the committee. If not, is there any public comment on item number 6 being continued until October, which has been requested by both parties?
Yes, I'm Peter Warfield. I'm not a party to this, and I'm not familiar with it, but promptness is an important aspect of the work that you do, and as is sometimes said in the law, justice delayed is justice denied. So if the parties have requested it, nonetheless, this is a public body doing public business, and I think it would be useful to have some sense of what was said with respect to this as to why this is being postponed. Thank you.
Is there any more public comment? Sorry. If not,
And I'm sorry, one other thing. When we get these requests subsequent to the posting of the agenda, if we can have copies at the meeting of the requests, that would be helpful, so I could see it, for example. Thanks. And members of the public, too.
is there any questions or anything from the body? Can we take a roll call vote, please?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims? Absent, sorry. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Grant?
Aye.
You have 7 ayes.
Great. Can we go to the next item on the agenda then? Item number 2.
Item number 2, election of chair and vice chair, election of officers, per Article 2, Section 3 of the bylaws.
So at this time, I'd like to ask Attorney Threat to explain this.
Yes, Madam Chair. Item 2 is the election of chair and vice chair, and under the bylaws, there is a very specific procedure that should happen for that election. If there's not an election for officers on or before July 1st of each year, then that means that the task force must schedule such an election, and it has to take action to schedule that election. It hasn't yet done that, so there's an opportunity for the task force to do so today.
So my understanding is that we can schedule this at any time before the end of the year, or we can also today, so we will not be able to actually hold elections, but we can also take nominees at this point, or if people would like to consider that, we can do that the next meeting, but we should schedule when we want to do the elections at this meeting. Member Nee.
Madam Chair, I move to schedule the election of officers for the next meeting, which would be September 4.
Second?
It's been moved and seconded. I'd like to open up for discussion with any of the other members of the task force. I'd like to open up to the members of the public for public comment on this item.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I would hope that we would see an election this time which would have more than 2 people who are nominated, 1 for each position, and then just elected. When considering who should lead the SOTF, you must consider a contender's leadership abilities. In 2 orders of determination, this year, 1 against Chief Sir in case number 12018, and 1 you're most familiar with is the case against the Clerk of the Board, 12050. In both of these cases, the chair of this task force voted against the majority and then used her discretion to direct both to EOT rather than to the compliance amendments for enforcement. While we might argue about whether or not that is an abuse of discretion, the result cannot be disputed. The San Francisco Police Department had no impetus at all to make any changes to their requests to improve their response to requests for public records. And the Clerk of the Board has simply refused to comply with your order and has openly defied your authority to even issue the order. The Sunshine Ordinance complaint process is an arduous one for all involved. Why should the members of this task force waste their time if the end result is not an improvement in opening government, but a degradation of the purposes for which the SOTF exists? An effective leader would use the energy of all of your members to move forward toward more open government. I would ask you to choose thoughtfully about who you want to lead you. There have been a number of things that have happened. If you look at your own website, There have been 2 orders of determination issued this year, period. The Education Outreach and Training Committee has not held one single meeting that was regularly scheduled. Every single meeting was canceled and a special meeting was held, and they weren't announced until 3 or 4 days before the date of the meeting. So the public has to rely on the whim of the committee to determine when those meetings are held. Now, if you can't do more than 2 orders of determination 8 months into the year, there's a problem. If you can't even support your own findings, there's a problem. And I think you really need to consider, are you really going to put in your time and energy and sit here only to have it come to nothing?
Is there any more public comment? If not, I'd like to, there's a motion. The one thing I would like to say, if there are any other nominees, please feel free to let us know so we can put that on the record for the 2 offices. If not, then you can nominate yourself or be nominated at the next meeting when we do the actual elections, so you have that time to think about it. Definitely open to everyone being a part of this process. Madam Clerk, will you do a roll call vote on this? So this is, will you repeat the motion for when we are going to hold elections?
So the elections for the task force chair and vice chair will take place at the September 4th meeting.
Okay,
That's the motion from Member Nee, and Pilpel seconded.
great. Can we do it? Thank you.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Grant?
Aye.
You have 7 ayes.
Okay, the motion passes, so next meeting we will hold elections. Madam Clerk, will you go to the next item on the agenda?
Item number 3, file number 12007, Education Outreach Training Committee has referred file number 12007, Library Users Association, against Supervisor Campos for responding late to an immediate disclosure request and redacting information from Bernal Heights Branch Library mural.
I'd like to ask the chair of the EOT committee to kind of refresh the task force about this particular case.
Sure. We started to hear this last month, and there were some documents missing, so we continued it to this month. This item has been around for some time. It was heard and a determination ordered in 2012. One moment. April of 2012. This was heard at the Compliance and Amendments Committee, was referred back to the full task force, and was referred to the Education Outreach and Training Committee. We attempted to hold a hearing on this twice and were unable to do so because the supervisor's office was not available the first time, and so we granted a continuance, and the second time they did not properly communicate with our clerk, and so we wrote a strongly worded letter that's in your packet at page 25, and there was a response 5 days later from the supervisor's office, which begins on page 27, although it looks to me like we only got the odd pages on the response from Supervisor Campos. What we were attempting to do at Education Outreach and Training was neither to relitigate the matter nor to determine how the supervisor's office had followed up with the instant request, but was merely to determine whether the supervisor's office had policies and procedures in place to respond on a timely basis to public records requests. Again, we were unable to do so because the supervisor and his office staff were unavailable at the time. We do have, again, part of the documentation. before us, but I believe that we have the supervisor present and the underlying complainant. So I think we can determine at the meeting today that either there are policies and procedures in place, in which case we can conclude the matter, or that there are not sufficient policies and procedures in place, in which case we have a range of options. That would be my summary. Thank you.
Thank you. At this time, I'd like to invite the complainant out to kind of give us an update of this case. You have 5 minutes to tell us what you'd like to tell us about this, if anything has occurred since.
Thank you. I'm Peter Warfield, Executive Director of Library Users Association. This case, unfortunately, for a number of various reasons, has dragged on since almost 2 years ago when we first made our request for information from Supervisor Campos's office on, I believe the date was October 27th, 2 years ago. I think that the statement of the chair minimizes what the purposes are, and the agenda does not describe at all what the purpose here is, other than to refer to a letter. The supervisor's office requested a postponement of the first EOT meeting, which was granted. Unfortunately, we weren't kept in the loop about that and showed up for a hearing that was to be postponed, and everybody but us knew about it. The second meeting wasn't just a matter of the supervisor not communicating with somebody. That certainly may have been a situation that happened, but the fact is neither the supervisor nor anyone from his office showed up. And one of the things that I think is unfortunate throughout this whole thing is that the task force and I think there's been ongoing and repeated failure to follow up on and to make determinations about how the supervisor responded after the original hearing. The original hearing found a violation with respect to the promptness of the response and with respect to the response that was provided, and required the supervisor to respond within 5 business days. The supervisor did not do so. More than a month later, 23 business days later, we got a response. The quality was poor. We got a mishmash of more than 300 pages in a completely different sequence from what was originally given us in redacted form. At a subsequent, when we commented on this in the supervisor's office, the aide said, if you don't like it, go complain to the Sunshine Task Force. At a subsequent hearing, the supervisor or his office said, yes, they could give the material in the same sequence as originally provided, only unredacted, but then didn't bother to do so until eventually we sent a reminder. There are so many untruths and, in fact, smears that have come out from the supervisor's office. It's pretty shocking, and those don't ever get acknowledged either. We hear about personal contact information redacted. We hear that repeatedly. Here is one of the pages that was redacted, your page 52, from Mauricio Vela, home/office, redacted. And on the next page,
Can't you put on the...
page 53, and these are just examples, from Roberto Y. Hernandez, Presidente, Latin Zone Productions. Well, that doesn't sound like a personal contact information to me. All the contact information, telephone, fax, email, all redacted under the claim that this was done under the guidelines of the city attorney. The most recent letter says that they came immediately upon being notified. Well, if you read the chair's letter itself, it says that there was a lengthy discussion and public comment before the supervisors folks showed up, and my pages are a little bit mixed up here, unfortunately. This week, May 13, this is the second paragraph of the letter of May 16th on your page 25. This week on May 13, the EOT committee heard the matter and no one was present from your office. Following lengthy discussion and public comment, the committee referred the matter back to the full task force. Well, I was there. And it appeared that the administrator, as well as one of the members, contacted the supervisor. And here in his letter of May 21st, he says, Hillary Ronan and I
Sorry, your time is up. If you could just wrap that last statement up.
Thank you.
Thank you.
Here they are claiming, my colleague Hillary Ronan and I immediately went to the hearing room, but the item had already been heard and closed prior to our arrival. I think that to put this out as something from sourced as a failure of procedures is to utterly trivialize and to not look into what happened and why and what might be the motives behind this, not just some little mechanical problem. Thank you.
Thank you. I'd like to invite Supervisor Campos up.
Facts and evidence.
I'm sorry.
Madam Chair.
1 second. Supervisor, are there any facts and evidence in support of Mr. Warfield?
There are plenty of facts and evidence.
Or people here to support that? If not, I'd like to invite Supervisor Campos back up.
Thank you very much, members of the task force. Let me just make a couple of points. I'm here to talk about how we got to this point, and you saw a letter which to Member Pilpel. My understanding was that my staff had sent a copy of the entirety of the letter, a 2-page letter. So if you do not have that, I don't know sort of why that is the case, but that was submitted in full to the task force. As my staff indicated in the letter signed by Stephanie Ashley, there was a mistake made where Ms. Ashley was not present at one of the hearings. And to the extent that that means that by extension I was not present, I take full responsibility for that. The only thing that I can tell you is that as a member of the Board of Supervisors, I unfortunately cannot be at every place that I would like to be. And in this case, we did delegate the responsibility to this individual. The fact that this individual did not show up and did not notify by email or in writing of the need for a continuance is something that I take responsibility for. It should not have happened, which is why I'm here to talk about this matter in person. Mr. Warfield, and I respect your rights to assert the protections that are given to you by the Sunshine Task Force, but I think it's really important to be precise in how we say what we say here. If you're talking about untruths, I'd like to know specifically what untruth you're referring to. You don't take testimony under oath in this task force. I actually wish that that was the case, because I'm an officer of the court, not only a member of the Board of Supervisors, but I'm an attorney. And everything that we do in terms of representing our actions or inactions and our failures, we do so with full honesty and integrity. As I noted before, we did fail to comply with the timing of the immediate disclosure request, where there was an issue, and that's something that I take responsibility, and you have with you in the letter the procedures that we have in place to address that issue. With respect to the substance of the information, what we did redact was the personal cell phone information that for the people that wrote to my office. And we did that based on the advice of the city attorney that was personal information under the California Constitution. It is not something that we did lightly. When when this task force concluded that information should not be redacted, we proceeded to no longer redact that information. In fact, we have a predicament right now where there is a public records request that specifically asks for that information. We have the city attorney's office, the ethics commission telling us that information should be redacted, But based on the guidance of this task force, contrary to what they're saying, we're going to give the person who requested the information that information. We want to follow the guidance of this task force when it comes to anything when it comes to public disclosure. The procedures that are outlined in the document that's provided to you basically note that we have designated a lead in my office, and that person is Hillary Ronan. When Hillary Ronan is out of the office, the lead becomes Nate Albee to ensure that public records requests are responded to as quickly as possible. We are also training our interns, and much of the work that happens in our offices is done by volunteers, people who live in our district, who are residents, many of them students, to make sure that they know that once a public records request comes in, that it has to be responded to as quickly as possible. The intern, once they see an email that has that request, immediately notifies the lead, who then proceeds to gather the information and to respond as quickly as we can. If it's an immediate disclosure request, they proceed to gather the information and try to respond the same day, if possible, but no later than close of business the following day. Depends on when exactly the email or the request was received. Once we have the information, we collect the information and send it to the person who requests the information. We also leave a copy with the office in the event that the individual would rather come personally to the office and actually personally inspect the documentation. So that's what we have done. If there is anything else that we should do, that we need to do, that this task force believes would be appropriate, I'm open to doing that. And again, I am here for any questions you may have.
Thank you very much. At this time, I'd like to know if there's anyone here in support of facts and evidence for the respondent. If not, I'd like to open up to the task force for questions. Member Nee.
Thank you. Mr. Warfield, please. I'd like to get to the bottom line here. And I think you stated that ultimately you did get the information you requested unredacted. Is that correct?
Yes or no? Best as I can, there are things missing, but I don't know that there was any documentation involved in what's missing. So to the best of my knowledge, I got ultimately what had been requested.
Thank you.
Any other members? Member Pilpel?
Yeah, to follow up with Supervisor Campos. And thank you for being here and not sending an emissary. It's good to hear. The policy and procedure document, and I have seen the rest of it. I think there was a second page to this. Was this something that your office developed out of whole cloth, or do you recall if this was adapted from policy and procedure that someone else had created? Do you happen to know?
This is actually something that we discussed, and I know that we also reference, some of the documents that are available, including the Good Government Guide that the City Attorney's Office had. So it was put together based on those discussions and some of the guidance that's included in there. But we also know that there are times when the City Attorney's opinion may differ from where the task force is.
So you're not sure if this was created on your own, probably?
I think it was probably, but what my point is, I don't want to say that we independently created every piece of it, because there might be things that come from the Good Government Guide.
Right, and it's certainly, let's be clear, this is not a comprehensive document. It's certainly not as long as the Good Government Guide or the Ordinance, but I actually think in some ways it's a very good condensation of requirements, and it may be something that we could adapt and encourage future members of the board, as people seem to come and go there from time to time, that offices like that could use, particularly with interns who also come and go. And again, it doesn't go into detail about redaction and other matters, but it does certainly designate a lead and reference timeliness of response. So I appreciate that.
If I may, Member Propel, we wanted to create a document that was able to cover all the things that were needed, but also that was short enough, because you have to understand that we have interns who range from high school students to college students, to college graduates, to law students and attorneys, and we have to be able to educate each one of them, and some of them come from, a period of 2 months to maybe, 3 months or half a year, and we have a large number of interns, so we need to make sure that every one of them understands. So it's a document, I guess, that has to work for different levels of understanding of the complexity of this.
Okay. Well, I guess to summarize, I am fairly satisfied that this document constitutes policy and procedures for handling requests, and to the extent that something was not handled on a timely basis, it was not because there wasn't a policy, it was for some other reason, and I anticipate that there will be general compliance from the supervisor's office going forward, at least as to timeliness. So,
Great.
Thank you.
Member David?
Supervisor Campos, 2 questions for you. One, I'm just curious, have you put this document on your website for the public to see?
We haven't put it on the website, and to be honest, this has been an internal document for us. One question that we had was whether or not this was sufficient, or whether the task force would add anything else to it, so that's one of the reasons we also didn't put it up.
And I'm curious, and I don't know, maybe this isn't a task force type of question, but as a supervisor, if you're getting one advice from the city attorney and one advice from the task force, how do you weigh, how do you decide which? I would imagine that has to be horribly difficult to
Let
deal
me give you the example on the issue of the information that was redacted, and you take, for instance, the information from Mauricio Vela, right? And the reason we redacted that information was because it was his personal cell phone. It so happens that Mauricio Vela has passed, has been dead for a few years. We just thought that it was out of respect to the family to make sure that that wasn't out there. As a lawyer, I actually agree with the city attorney's office interpretation. I do believe that if a court in California were to decide the issue, that the case law is such that I think that a court would say that information has to be redacted. I believe that. That said, I'm an elected member of this board, and as such, I have to follow the guidance when it comes to public records and to open government of this body. And so as much as I agree with the city attorney, because this task force said that we should not redact that information, I'm going to follow that guidance because I respect the role that this body plays. And so I agree with the city attorney, but I think that the right thing to do would be to follow the guidance of this task force.
Thank you.
Member Washburn?
Actually, partially addressed my question. I wanted to be a shameless opportunist, and you're standing here in front of us, and wanted to ask, your opinion about that very matter. And this has come up before us over and over and over. The next item on the agenda, it's the same issue. And so I'm wondering if there's any way to come up with a change in the ordinance that would satisfy both sides of this. Our position has been that if a member of the public is going before a public body, for example, in this case, I guess, applying for a slip in the marina, then in a sense that information is public. Or if somebody's applying to be a member of, say, this body. This came up for me personally when I applied to be a member of the task force, and I was called at home on a Saturday morning by a member of the public, and I went, wait a minute, where did you get my home phone number? So, I see both sides of it, but I guess we're, and after much education on my, for me, by members of the public, I've come to believe that in these cases where members of the public are appealing to a public body or speaking before a public body, the speaker cards, or testifying where there are other members of the public who would like to meet with them to lobby government, in those cases, it's, in a sense, they're making their information public. So I'm thinking maybe an assumption that this information is public unless the member says otherwise, and members of the public should have that made clear to them at all times. If you do not want this information disclosed, let us know. We will, we will keep it private. I don't know. This is very, very hard.
I certainly would be open to helping in any way to clarify, the law. It is confusing because it's not just the city attorney, it's also the Ethics Commission, from what I understand, saying that the information should not be disclosed. One case where, to be honest with you, I don't know what I would do, notwithstanding my respect for this body, is what happens if we happen to get an email from a domestic violence victim who is reporting something, I think in that case, I would be inclined to redact that cell phone in that name, so it's tricky.
Member Nee?
Yes. A couple things. First of all, addressing what you most recently said regarding somebody who might be in danger. There are exceptions that can be carved out from the disclosability of personal information, and if, as a matter of fact, there is reason to believe that that disclosure would put somebody in danger, I think that does justify redaction. Also, as Member Washburn suggested, it might be good practice to, as standard practice, as routine practice, to ask persons who contact you whether they want their personal information disclosed or redacted, and give them that option. And if they don't respond, then the default lies with disclosure. Yeah. I believe actually a couple other things. I believe actually there is some case law on that. There was a court case that did establish that personal information is disclosable except in very narrowly defined circumstances. And lastly, in the past, when the task force has found that personal information is by default disclosable, I believe that participants in those decisions have included past voting attorneys on this task force. I believe Member Erica Craven Green was one, and I believe Member David Snyder was another. So there is, I think there is legal precedent and attorney counsel to back disclosability as the default.
Thank you.
Any more questions? Sorry. At this time, I'd like to invite the complainant, I'm sorry, thank you, the respondent back up if you have any concluding remarks, or are you? Okay, thank you. I'd like to invite the respondent up, for the complainant up, for any rebuttal or conclusions. You have 3 minutes.
Yes, thank you. Peter Warfield again. I would like to amend the answer that I gave to Member Nee. The fight to preserve the Bernal mural, a community-created mural, it was a wonderful thing, and that was supported for renovation by many people, including, for part of it, Supervisor Campos himself at one time. The provision of the information with as much effort to fight about it and with as late a time period as happened was not what I asked for, Member Nee. That mural has now mostly been painted out, basically destroyed, so the timeliness was a very key factor here. And so in that respect, I did not get what we asked for. Supervisor Campos says, show me what's wrong. I think I already did. There was the claim continuously made that these were personal contact informations to protect the privacy of the people involved. Mauricio Vela had been dead for a year or more at the time we made the request. A dead person doesn't really have a risk of privacy problems from somebody living. And the president and his, if you look at the pages I cited, it's clearly labeled home/office. And so is the other example that I cited, that's not personal. Page 53, Roberto Y. Hernandez, President, Latin Zone Productions, that's not a personal contact. With respect to the claim that they didn't want the family bothered or some such thing. In fact, Mauricio and we were on the very same side of preserving the mural, and of course so was Roberto Hernandez. He said, today I urge to help save the mural. I can't believe people would want to destroy art of the people. What Supervisor Campos wanted to do was to prevent us from making common cause with folks who agreed with us and with whom we agreed. That was the real reason for all this huffing and puffing. And as one of your members said, there are plenty of exemptions to the requirement to disclose in the Public Records Act. They're specified, ongoing police investigations and so on. There's plenty of that. And this is not one of those things. In fact, there are many people who wish their material would be disclosed. As I said, this has been a history of repeated violations, of repeated latenesses, and of repeated untruths. I immediately went to the hearing room, but the item had already been heard and closed prior to our arrival. Your own chair of EOT letter says that they came only following lengthy discussion and public comment, and the committee referring them back to the full task force. I asked you to take action for ongoing willful violation. Thank you.
Thank you. If there's no more comments, I'd like to know if there is, with this new information, if there is a motion to find a violation. Attorney Threatt?
Madam Chair, members of the task force, this is a matter that's on referral from EOT to the task force for consideration of either closing the item or further enforcement action. There's already been a violation found, so the alternatives before the task force could be, as the complainant has suggested, a referral for ongoing willful violation to an appropriate enforcement body, some other type of referral, or to close the matter out.
So just to be clear, if someone wants to find an additional violation with the new material that we have, one of the members is able to do that, or a referral to
Madam Chair, I guess I'm not clear what your question is when you say an additional violation. What you mean by that, if you could
just
explain.
based upon all the new information, what Supervisor Campos has provided, and listening to Mr. Warfield, if they found that there was something that they still were not pleased.
Well, if the task force finds that the order of determination was not complied
fulfilled
with, then there can be a referral for failure to comply with that order.
Yes.
There can be a further referral for willful failure.
Yes, that's
to comply, and the task force also has the option of not making a referral.
great. Thank you. No, I can.
I think we don't. Right.
If there's no any motion, then I will find this matter concluded.
Public comment.
Oh, thank you. Sorry.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, I do believe this should be referred to the Ethics Commission. Mr. Campos has gotten up and told us a whole bunch of things. He's a very intelligent guy, he's a lawyer, he's a member of the Board of Supervisors, yada, yada, and yet we're treating this like he's some clerk who started last week or one of his interns who doesn't understand the law and the requirements. This is a case that dragged on for 20 months. The Arts Commission was found both by the civil grand jury and the Comptroller's Office to have committed grievous violations of its duties, including not keeping track of public art and not maintaining public art in accordance with their mandate. And this was a case where we now have, as a result, more public art on a public building paid for with public money, and there is absolutely nothing saying who's going to maintain that or fix it if it gets damaged or anything else, because this was all done in a private fashion. They say community process, but try to figure out if that mural gets damaged, who's going to pay to fix it? If it gets dirty, who's going to pay to clean it? There's nothing on the public record that shows that. Now, for Supervisor Campos to come in at this point, since this law has been in effect since 1999, and say, oh, well, we didn't have any procedures, and it took us 20 months to figure this out, and and I don't know what the proposition is. Oh, well, we didn't understand what our requirements were under the law. We didn't understand that we were supposed to come to these meetings that we didn't show up for. We didn't understand that if we had just talked to Mr. Warfield, we could have given him what he wanted right away, and he could have had it in time to use it. Instead, what Mr. Warfield got, and whether this was intentional or not, I can't say, but the result is what's important. He got the information too late to use it for the purpose intended. What's the point of having a public records request if it's like, well, good, you want to fight us? We'll just withhold the records you need to fight us until it's too late. We'll give you a fait accompli and simply say, well, we fixed it now, so the next person who comes up, And the question is, was this posted to your website? What is the next time going to be? Mr. Campos delegated authority to people in his office. Whether they are interns or a staff or whatever, delegation is not abdication. He was responsible under the ordinance for seeing that these records requests were replied to in a proper and legal manner. He failed to do that. And coming now after all this time and saying, well, now that I've finally done it, let me off the hook, is what I feel he's essentially doing.
Is there any more public comment on this issue? Thank you.
Hi, Kate Patterson, San Francisco Arts Commission. I just wanted to let you know for your own edification that at the Ethics Commission, where they heard the case regarding the speaker cards, where information was redacted, the Ethics Commission did not choose to pursue the matter and did not find the Arts Commission in violation for redacting the private information. So I just thought that would be a bit of information that might be helpful. And additionally, I always try to seize a moment where I can sort of correct the record. And the mural in question on the Bernal Heights Library did not belong to the city. It was not in the Civic Art Collection. The Arts Commission had no responsibility in terms of maintaining that mural, and there was an extensive public process, and you can read the minutes. They're all in the Visual Arts Committee minutes. Thanks.
Thank you. More comment on this particular case?
Yeah, I want to clarify that the Bernal Heights mural was the work of one particular artist. The city had an obligation to notify his heirs that this was set for demolition, and because the Arts Commission dragged it out by failing to appear and postponing, people were not notified in time.
Thank you. Is there any more public comment on this particular case?
Yes, thank you very much. Stop the corporate rape of the public library. Don't give money to the Friends of the Library. Don't accept money from the Friends of the Library. I was here, 5 or 6 years ago, and I thought we understood at that time, and the task force agreed that if you're going to limit public comment, you need to provide the speakers with a timer. That was accepted then. I'm grateful to Mr. Hart for supplying me with a timer. I used to bring my own timer back in those days, and I've misplaced it, and I thought that would be addressed by now. I was a little bit disturbed by the discussion I just heard. I came in the middle, and I assumed public comment had taken place already. As you know, as members of this task force, the requirement for public comment is that it be called before or during your deliberations, not after the chair says, well, I'm going to close this matter. The reason is so that the public comment will be meaningful testimony and be incorporated into your deliberations. The fact that you've turned around and allowed it as an afterthought still undermines that crucial, important point, which is that you have not incorporated and given respect to the public comment that the Sunshine Ordinance and the Brown Act envisaged. Now, I'm shocked by another part of this discussion, and that is both Mr. Campos, some of your own members, think that their opinion matters. If you're going to appeal to the idea that people victims of sexual abuse or domestic harassment or whatever need privacy, the state legislature has addressed that problem. And you appeal to that aspect of the law and provide an exception. You know, this doesn't devolve to your opinion about what the social values are. The law comes down to you and says you're required to provide disclosure of people who have voluntarily put their personal information into the public record as part of public deliberations so that they can be part of an open discussion. The fact that you have an opinion about whether that should be enforced, it's up to them to enforce it. It's up to them to disclose or not to disclose, and once they disclose a public record, they have done that, and people wishing a public record have a right to it. I wish I had time to go in to the whole issue of the mural, because that was a huge scam that this is overlaid. Thank you very much.
Thank you. Is there any more public comment on this particular case?
Yes. Well, my name is Dominic Mianchi, and first of all, I wanted to commend the supervisor for releasing the information and for putting policies in place to prevent that from happening in the future. And I also commend him for not listening to the city attorney's office and to his own opinion as to whether he should release the information and to listen to, the determination of the board. Because I agree with the previous speaker. It's not my opinion or his opinion. It's the law. And I'm an attorney also, and I have a different view from him as to whether it should be disclosed. And as Mr. Nee suggested, there are exceptions, and if it's not within the exception, there's a default to disclose. Now, Member Washburn mentioned, I think people should be told that when they put information forward, that it may be sunshine and their information may come forward. That gives everybody the choice of whether to put that information forward or maybe to withhold their phone number or address, or to have a P.O. box or to have a separate address which they don't mind disclosing for mailing purposes. I mean, that is everybody's choice. So maybe just a little disclosure on a website or on documents saying, the information you provide, please be advised that under the Public Records Act, the information you provide may be subject to disclosure. And I think that would solve the whole problem.
Thank you. Is there any more public comment on this particular matter?
Livingston. Just a couple of comments and maybe observation. I'm not a lawyer. I don't have a staff or interns to blame for not doing what people expect me to do. When I first came to San Francisco, I fell in love with that mural at Bernal Heights Library. It was a beautiful mural, and my understanding is it was a community effort. It really needed to be restored, but I think time just allowed it to go because some people had bigger uses for those walls or had other priorities. I know it's been, how long? A year, maybe 2 years since the question of that mural and changing it came up, and I know a lot of people were involved. I went to several events where I was absolutely surprised to see how little people knew about what was going on. My friend Peter Warfield is a very meticulous and conscientious person who cares a lot about libraries, and I know that for at least 2 years running he's been trying to make people aware of what was going on out there. And I don't think, my observation is that I don't think that there was sufficient public input about what happened. I could go on and on about it. I think it's a shame, or in Spanish, una vergüenza. You know, it was a shame that Victor Jara is more or less erased from those walls. There was a certain amount of soul power in that library and the mural there, which is disappearing, and people every day are asking what's happened to the soul of San Francisco. I actually like David Campus for a lot of reasons. I was very shocked to see that such and such came about, but I have a sneaky suspicion it was an election year, and, well, we'll look at it. The Board of Supervisors is going to possibly lose 2 so-called progressives. Everything's turning to the right, including our progressives. Maybe the soul of San Francisco. You know, I'm going to forgive and forget a lot of these things because I admire people, and I hope that time will change some things and improve San Francisco. I would love to see a statue of Victor Jara somewhere to make up for this terrible thing, and I do think...
Can I interrupt you for a moment?
Yes.
Mr. Tesh, can you please sit down while he's talking? Seems a bit disrespectful. Thank you. You can look during public...
Well, I'm pretty much finished, but I do believe in the Sunshine Task Force Committee and your duties, and I would like to see that you meet more regularly. I'd like to hear less about interns and maybe people paid to do these jobs. That might help a lot of people. But anyway, that's about it. One last observation. People who generally say, to be honest, oftentimes are not being honest in my experience.
Thank you very much for your comments. Are there any more public comments on this particular matter? If not, this case is closed. Thank you both for coming today. We appreciate it. And the matter is concluded. Since it's 5:10, I'd like to take general public comment at this time on anything that is not on the agenda. So I'd like to invite people that want to do public comment. You have 3 minutes to talk about.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. Section 6715, public testimony, subsection D reads as follows. A policy body shall not abridge or prohibit public criticism of the policy, procedures, programs, or services of the city or of any other aspect of its proposals or activities or of the acts or omission of the body on the basis that the performance of one or more public employees is implicated or on any basis other than reasonable time constraints adopted in regulations pursuant to subsection C. This section of the ordinance which I have just read was blatantly violated at your last meeting by Member Todd David. Interrupting my public comment, going on a tirade, and then storming out of the meeting shows a total lack of understanding of the ordinance. And I might add the Bill of Rights of the Constitution. The fact that a person is eventually allowed to complete their public testimony does not lessen the offense. It is perfectly legitimate for any member of the public to appear before a board or commission and call to the attention of its members actions of individual members. Far from being any sort of personal attack, It is nothing less than petitioning government for a redress of grievances. While any member of your board has the right to respond, they do not have the right to mount an attack against a member of the public for their comments. And that was exactly what happened. I was attacked. I was accused of being a poor sport or sour grapes or whatever, and it was done in the middle of my comment. There was no effort made by the presiding officer to get control of it. And then it was simply, okay, well, now that you've been interrupted and your whole train of thought's gone, and most people probably don't remember what you were talking about before this whole thing started, we'll let you have the rest of your time and just do no harm, no foul. Bottom line was, you don't have the right to interrupt me in the middle of what I'm saying. If you want to respond to what I have to say, you are more, I believe in what Voltaire said. I may not agree with what a man has to say, but I'll defend to the death his right to say it. So if you disagree with me, say it. But don't interrupt me in the middle. Don't make charges and accusations that I'm doing this or I'm doing that, which are designed more to make me look bad or disparage my comments. Every member of the public has the right, and if I feel that one member of this commission or any commission needs to have an action they have done addressed, it is perfectly within my right and any citizen's right to address the full board about that individual person and name them by name. That's what the Constitution is there for.
Thank you. Is there any more public comment on items not on today's agenda?
Yes, thank you very much. Stop the hate, stop the ignorance, don't give money to the Friends of the Library, don't accept money to the Friends of the Library. I usually try to address the public bodies as an anonymous citizen, but I, in fact, am James Chafee. I was the first vice chair of this task force back in 94 and part of 95, and I was the chair in the second year of the task force, 95 and part of 96. During my tenure, we passed what we called the Sunshine Bill of Rights in April of 95. And actually, if you look at this, we made a nice poster of it, and I asked your secretary to distribute the copies that were available in a pamphlet form. We also drafted these in another format. I'll give this to your secretary in a moment. I hope you'll have a chance to look at the poster. It was calligraphed by a prominent calligrapher named Kathy McNicholas, and very nicely done. You'll notice that the poster, not the Sunshine Bill of Rights itself, is dedicated to Joseph Van S. Ballesteros. Mr. Ballesteros was an aide to the supervisor Kevin Shelley, who was primarily involved with shepherding the original Sunshine Ordinance through the board and getting it drafted, and he was one of our early members. And he passed away from AIDS-related syndrome earlier that year, so we, having a soft spot in our hearts for his passing, dedicated the poster to him. I like to remind you of this several times because back in those days, we had a very positive outlook on developing the Sunshine Ordinance Task Force. And part of that, I think, that was very crucial is that we did the work ourselves. We didn't defer to a secretary employed by the clerk of the board or our representative from the city attorney. We did the work ourselves and had the control ourselves. And I think you'll find that produced a different context. If you look at the context we have now, it's evolved into a very negative and very confrontational thing as the people that serve you try to minimize their jobs, try to minimize the effectiveness of this task force, and create an atmosphere of resistance that I think is very dangerous. I have a complaint coming up shortly, and I think you need to understand that my involvement takes place in this long framework. Thank you very much.
Thank you. there any more public comment on any matters not on today's agenda?
The Sunshine Ordinance requires that the public comment be taken before or during your deliberations, and I think it's most unfortunate that that doesn't always happen. And in fact, we had multiple people from the public on the previous item speak, and then there was no discussion, no even opportunity for discussion given by the chair to the members of the task force itself before her decision to close the matter without action. I think that's most unfortunate and most inappropriate. I think that the members of the body should insist not only that the public have its full rights to participation, as Mr. Chafee's presentation of the Bill of Rights would help you to do and guide the public, but that you yourselves also have your right to have an opinion and to express it and to discuss matters without the chair steamrolling over any possible comments or questions or thoughts and declaring a matter closed. Thank you.
Is there any more public comment? If not, I'd like to continue on with the next item on the agenda.
Item number 4, file number 12058, Compliance and Amendments Committee has referred this file, Dominic Mionki against the Recreation and Park for allegedly failing to provide records requested pertaining to berthing contracts.
I'd like to invite the chair of the Compliance and Amendments Committee to update the entire task force on this case.
Well, I'd like to hear from the members to the complaint, the parties to the complaint in a regular fashion. But reading from the draft minutes of the last meeting of the Compliance and Amendments Committee, we voted unanimously to refer the matter back to the task force with a recommendation of referral to the Ethics Commission for enforcement of violating 6734, 6726, 67.21I, and for the chair, myself, to draft a letter to the city attorney stating that the Recreation and Parks attorney is in violation of section 67.21I. So this matter is going to sound a great deal like the one we just heard from the Supervisor Campos and member of the public, Warfield. But just to let you know how it arrived here, reading the motion that we passed. So,
great.
Carry on.
So I'd like to invite member of the public, I can never pronounce your last name, I'm sorry, the complainant. I'll just say the complainant. And you have 5 minutes to kind of update us on anything that you'd like the entire task force to know about this case.
Hello again, my name is Dominic Mionki, and without disagreeing with you, Member Washburn, this case is different because the supervisor did comply with your wishes, even though it might have been a few, I don't know how late it was, but he did comply. In this case, there is no compliance, and there's a continued writing of letters, which last time I was here, we determined that the previous letter that the custodian of records signed was not written by her, but was rather written by the district, the attorney's office, a member of the attorney's office. I think we should find the name of the person who wrote the previous letter and find out who wrote this letter that was also submitted. Perhaps the custodian of records wrote this, perhaps not. It's up to you whether you want to ask her. But we should find out who is writing these letters and maybe send that, instead of just sending them a letter, which they get lots of letters at the attorney's office, I'm sure, but actually send that referral to the ethics, send that person who wrote the letters in violation of 67.21I, actually send that to the ethics. I don't know the procedure, but if you can, find a way to do it, because I think otherwise they're just going to ignore the letter and put it in a circular file. Now, as far as my particular situation, I wanted to make sure in writing that Mr. Ginsburg knows about this, because I don't want to go in front of the Ethics Commission and say, well, I don't know anything about it. So I wrote him an email, and then the next day I sunshined it. So I have copies here for you. I have 10 copies, but you probably only need one. And it's an email that I did to Mr. Ginsburg explaining the situation. And in the past, this happened once before, about 2 years ago, and and you made a determination in my favor to release some documents. I emailed Mr. Ginsburg. He did not answer me, but within 48 hours, I had the information. This time I emailed him, and I still do not have the information. But I think this shows that the email was received by him at Park and Rec, because I received it through a sunshine request. What else is there? There was some talk. I mean, I don't recall exactly who said it, or if it was a member of the public or one of the members here. There was something about, and again, I have not looked into how the Ethics Commission works, but I think you have to hold a particular person responsible, not a department. And I think that came up, and I think that the referral should be to Mr. Ginsburg to ask the department to produce the documents, and an ethics violation against Mr. Phil Ginsburg. And that's it. Thank you.
Thank you very much. Is there any member of the public that would like to introduce any more facts or evidence in support of Mr. Bianchi? Let me get it right.
Can I leave these here for you?
If not, I'd like to invite the respondent up to kind of give us the latest. Is the respondent here? Great. Oh, hello, Olive. And you have 5 minutes to give us kind of an update of what's going on since the last time.
Good afternoon, members of the Sunshine Committee. My name is Olive Gong, and I am the custodian of records for the Recreation Parks Department. And in responding, I would just like to, again, make the following points as outlined in our December 19th letter to this committee, that we have complied with Mr. Mayunchi's request within the 10 days as he was required under Sunshine Ordinance, and we had lawfully redacted our private residence addresses and telephone information, and that these individuals have a substantial privacy interest in their home addresses and home telephone numbers, and that there is no justification for violating the right to privacy by disclosing the private home addresses and phone numbers of waitlist applicants, because their information is unrelated to Rec and Parks' performance of its duties, and that the Rec and Parks redactions do not violate Sunshine Ordinance provisions regarding contracts. That's all.
Great, thank you. Are there any members of the public here to support Ms. Gong's statement with any facts and evidence additional? If not, I would like to open it up to the task force members for Member Pilpel. Member David, I'm sorry. David.
So I feel like here we are again, and I know that I think I'm in the minority on this issue with the task force, but I feel like I feel like that the city is in this catch-22 situation, that they're being advised by the city attorney and the ethics committee that it's okay to redact personal information, and then we as the Sunshine Task Force as a whole are saying it's not okay. And I feel like that this is there's no right or wrong. If we refer this on to the ethics committee, I think we all know the ethics committee is going to say that they didn't violate that that they don't have to disclose they don't have to remove the redactions. So I'm kind of like, I feel like that we as a task force need clarification with the ethics and with the city attorney's office so that we're all sending the same message. Because we're going to vote and we're going to say there's a willful violation, they did not do what we told them to do, then it's going to go to ethics, and ethics is most likely going to say what they did was absolutely fine. And so it becomes just this circular conversation. And I don't see how that is helpful I don't see how it's helpful for anybody. And I kind of am of the mind that if, the city attorney is elected by the people of San Francisco, and if they disagree with his interpretation of the Sunshine Ordinance and the state of California's Constitution, he can be replaced. And that when a new city attorney comes in, if he has a different interpretation, then that would then change this conversation. But until that happens, I don't know what the Rec and Park Department is supposed to do. Literally, like, are they supposed to listen to their attorney? Or are they supposed to listen to the Sunshine Task Force? Or do they have to go to ethics to have their attorney's advice be backed up? So I don't know.
Member Nee, and then Member Pilpel.
Ms. Gong, please. Of all those people whose personal information you redacted, did you contact any of them asking if they wanted that information redacted?
No, we did not.
Did any of them approach you or anybody else in the department and ask that the information be redacted?
No.
So what reason then did you have to believe that redaction might be advisable?
It is just our general policy to redact personal information from documents.
Why?
Why?
Yes.
Well, again, referring to our letter, there is no justification for violating the right to privacy by disclosing the private home addresses and phone numbers of our waitlist applicants.
Did you ask these people if they felt their privacy was being violated?
No, we did not contact them.
Did any of them tell you that they felt their privacy would be violated if the information was disclosed?
No.
Ms. Gong, I have a question. So, I don't know if you were here for the previous case, but since the last full task force, and you know that we ruled in favor of the complainant, what has your office done? Anything? When I listened to what Supervisor Campos did, he did made a determination within their office to unredact certain information. So it seems like, I think that one of the biggest concerns for us is, is there anything that your office has done? Because obviously members of the public, there are certain members of the public that do believe that redacting is not right in this particular case. So, I think back to what Member Washburn was saying about perhaps, creating a policy within your office that would put that on your, on the form or something like that. So
No, there has been no change in our policy.
And so nothing was suggested? Nothing was? Okay.
Nothing.
Okay. I think Member Pilpel was next, and then I'll go down the line. Go next. Member, okay.
Thanks. I'll try to be as brief as I can. I have a number of questions, though. To Ms. Gong, the policy that you just referred to, it's our department's policy, blah, blah, blah. Is that policy in writing anywhere?
No. This is just our general policy. We are following.
I understand. I'm asking if that policy is in writing anywhere, other than in the December letter to us.
I don't know.
You're the custodian of records. If anyone would know, you might know. You don't know?
Can you ask the question? Can you say your question again?
The policy that you referenced, that it is the department's general policy to redact personal contact information, et cetera, is that policy in writing somewhere?
Well, I refer, when we redact personal information, we are looking at the Good Government Guide.
I'm asking if your department's policy...
I don't know. I don't know if it's written down somewhere.
Okay. The response to the full task force dated July 29th that you summarized, was there an earlier response to the Compliance and Amendments Committee?
Earlier?
Was there any response in writing to the Compliance and Amendments Committee indicating whether or not you had complied with the order of determination?
Let's see. We had written a response July 29th in response to the order of determination. Is that what you're saying?
The Compliance and Amendments Committee was on July 16th. The order of determination was June 12th. Was there a communication to the Compliance and Amendments Committee indicating whether or not you were complying with the order of determination?
We responded that we would just have the same response, that we would just
So what I'm hearing is no.
There's no change in our response.
There was, I believe, a letter sent to compliance, but it was the same letter saying that they would not be compliant. They would not.
It's the same substance of the
Exactly.
Right.
July 29th letter. Okay. So moving on to the substance of the July 29th letter. And by the way, I find it very interesting that your letterhead here, 2.5 years later, still has Mayor Gavin Newsom in the top right corner. You might want to change that. The advice from the city attorney to continue to redact and not disclose that home address information. Can you tell us who the city attorney was that you received advice on this matter from?
That was Francesca.
Francesca Gessner, correct? Okay. Can you explain to us, since we haven't seen any communication between you and Ms. Gessner, the basis for that advice? Since that is advice relative to compliance with the Sunshine Ordinance, which must be made public under the ordinance?
What is your question?
Can you explain to us the basis for Ms. Gessner's advice not to provide the unredacted information?
Why did she, what the basis of her advice? I don't know what the basis of her advice is.
You don't know that?
I mean, she's giving us advice.
Right.
I don't understand.
If I can assist, perhaps, I think what Mr. Popo wants to know is, in providing the advice not to redact, did Ms. Gessner, is that her name? Did she cite any statutory or case law that would support that position not to provide the information?
She did no. We had asked for her advice before, and we had...
Okay, but what statutory or case law did she cite in advising you to redact?
Let's see. Well, in December 19th letter, we had made many citations of the law. Do you want me to read it?
No, we're familiar with that. The question was more in light of the task force's determination that the record should be made public in an unredacted fashion. Did that not change her analysis and recommendation to you?
No, it's the same.
Okay. Do we know how many redacted records are at issue? How many records were provided to Mr. Mayanki in a redacted fashion?
We had sent it to you in the attachment.
Well, we've seen examples. I don't know if we've seen all of them.
Yeah, those are all of them.
Oh, so...
There's only like 5 or 6. There's not very many records.
5, Ms.
It's not, there's not.
Mueller, Pincus, Slobe, Holloway, and Rafe. That's the extent of the wait list?
Nancy Mueller, Pincus, Slobe, Holloway, Rafe. Yes, that is it.
Okay. Mr. Mayanki, you're not disagreeing with that? Okay. So it's literally the contact information for 5 people. That's what we're talking about here. Okay. I mean, we've already adjudicated the matter, and the department is saying that it is not going to comply. So I guess I'm done with Ms. Gong. To Mr. Threet, can you remind us what our options are here when a department is saying very clearly that they disagree with our decision and will not comply? On a matter of redaction, not broadly, but in this kind of case.
Well, they're the same options that I enumerated on the previous item. You can make a referral for failure to comply with your order of determination. You can make a referral for willful failure, or you can not make a referral.
Okay. If we make a motion to refer the matter, do we have a sufficient evidentiary basis to cite either Ms. Gong, Mr. Ginsburg, the department generally, or somebody else? How specific do we need to be, and do we need to give any special notice so that they're very clear that they may be referred either with or without finding a recommendation of willful failure?
Give me a moment to look at the order of determination, and I'll...
Member Oka? Oh, I'm sorry.
Yeah,
Did you have a question?
Ms. Gong, will you come up, please? I'm going to try to ask Member Pilpel's question, and this is a yes or no answer. I don't need any explanation. I just want a yes or no answer. Does this policy that you refer to exist in writing?
I mean, it's in writing, it's in the Good Government Guide, you know.
That's not what you're telling us, that it is the department's policy to redact
personal information.
I'm asking, where is that policy? Is it in writing, yes or no?
I don't know.
Thank you.
I just don't know.
Attorney Threet is going to answer.
Through the chair to members of the task force, and Member Pilpel asked about what kind of notice needs to be provided for a referral for willful failure. The order of determination, in my recollection, which is a little hazy on the original complaint, is that the complaint was against the department itself and not a specific individual in the department. And the order is that the department provide these records. The department has refused to do so. Certainly, it's very clear the department can be, referred, and possibly Ms. Gong, since she's been appearing here for failure to comply with the order of determination. What's less clear to me is whether there's sufficient notice to the director of the department head, Mr. Ginsburg. I didn't hear part of the testimony, and I believe Mr. Mianchi was talking about whether Mr. Ginsburg was aware of these matters. I didn't hear that. So I don't know whether he has sufficient notice to realize that he could be implicated in this.
Because I think what Mr. Mianchi did show was the letter that he sent directly addressed to Mr. Ginsburg, and then he received a response from Olive. Is this correct? Tell me, Mr. Mianchi. Come up, please. From Olive, acknowledging receipt of that because he sunshined that actual request that he sent specifically to Mr. Ginsburg. And you can ask Mr. Mianchi, but that's my understanding.
I have a copy of what I sent to Phil Ginsburg right here. And I emailed that to Phil Ginsburg, and me and Phil Ginsburg have, over the last years, on a regular basis, exchanged emails in a very friendly manner. I waited 24 hours and I sunshined it, just because I wanted to make sure that he had received it. Now, it also, you can keep, I have many copies. I bought 10 copies if you all want one. But if it's a problem, I really ask that you specifically ask Phil, send this to the Ethics Committee with Phil Ginsburg. If you want me to amend my complaint, if there's a process for doing that, or I can bring the complaint again. I mean, I don't want to indict a department over, I think that's silly. I mean, if you don't feel you have enough, I will start the process over, or if you let me amend it, or if you accept this, find a way so we can send it, address it to Phil Ginsburg rather than just an empty department. And I don't want to hold Olive responsible because she didn't even write the letters, as we found out from the last at the last hearing. Thank you.
Thank you. Attorney Three?
Based on this email, I think that Mr. Ginsburg, the department head, does have sufficient notice that this matter would be before the task force and had sufficient time to instruct his department as to how it should respond to the order of determination prior to this hearing. The provision for willful failure, 6734, provides that it is the willful failure of an elected official, department head, or other managerial employee to discharge its duties that can be the subject of a referral. So it does need to be a department head. Ms. Gong is not an appropriate, absent other facts, it appears Ms. Gong is not high enough or have the appropriate duties to be referred for willful failure. But Mr. Ginsburg would be an appropriate referral.
And because Mr. Bianchi submitted that letter to Mr. Ginsburg and we got the response back, we can acknowledge that he is aware of that because Ms. Gong responded on Mr. Ginsburg's behalf. So
certainly it's apparent that Mr. Ginsburg received the email.
Okay.
And generally delivery is sufficient notice of any kind of notice of that kind.
Okay, thank you.
Can I just make a clarification? Somebody would ask me to.
Come up, what'd you say?
I just want to make a clarification. Ms. Gong responded to my Sunshine request. She didn't actually email me back. She sent me the email that he received.
Okay.
Because I asked, please send me the email that I sent to Phil yesterday.
Okay.
Just to show. Oh, and just one quick comment. If it's their policy, written or not to disclose private information, I think earlier testimony from her disclosed that when I asked for the birthing contracts, which also arguably contain personal information, it is not their policy to redact. And that if I ask I can ask for all 650 birthing contracts if I want to waste that much paper, and they will send them unredacted. And I think it might be important for you to follow up with her what the differentiation is between a contract to rent a slip with personal information as opposed to a contract to get a slip in the future. Now, and again, if you call this is an application, but there's a fee.
Yeah.
I pay a fee. There's a duty on the other side to give me a slip when it shows up. I mean, that's a contract. So they're both contracts.
Got it.
So when she says there is no personal, it's their department policy not to disclose personal information, you may want to clarify with her about that because she will tell you that she has given me many times birthing contracts without redactions.
Perfect, thank you. Member Washburn?
I'm looking at, this is actually for the other members of the task force. I've been trying to think about what, if we write a letter to this city attorney's office about this, and what we might discuss in that letter. And looking at the second page of, this is on that Mayor Gavin Newsom letterhead, the recent letter from July 29th. And the top of the second page, give me a minute here, okay. The city, it's the second page, I'm looking at the electronic copy, so, but it's the letter dated July 29th, and it's page 70 of the packet, and it's regarding what the city attorney's good government guide says. And, quote, the general rule is that departments should not disclose home addresses, personal phone numbers, or personal email addresses of members of the public. Such personal contact information typically sheds no light on the operations of city government. So the first sentence is saying the general rule is, okay, that doesn't say this is an ironclad policy, it's just the general rule. And then the second sentence, I think, is particularly pertinent to this case because it says, such personal contact information typically sheds no light on the operations of city government. Well, in the case of the wait list, if I remember the case, and I'm just going by the compliance and amendments because I wasn't here for the original hearing, but the reason Mr. Mayanke wanted, and I think I got your name right, wanted this information was that the first person on the wait list didn't get the next available berth. It was somebody further down. And so he wanted this information to let the people who were skipped over know about this. Now, this is about the operations of Rec and Park. This is part of what they do, is to enter into contracts with members of the public for these berths. So, this information was relevant to the people on that list. It had to do with what the Rec and Park Department does. So for the good government guy to say, well, in some cases, and usually this information doesn't have anything to do with the workings of the government. Well, sometimes it does. And so I'm just trying to brainstorm about what to put in this letter if we decide to write it, and how we can start having a dialogue with the city attorney's office about this sticky point that we're going to keep butting heads against.
Member Sims?
Well, I think that, I guess you bring up really good points, and I think that I was looking at the December 19th, 2012 letter on the electronic version. I think it starts at page 76 or something, where they laid out why they should not disclose the information. And I think the policy that the Rec and Park has to say that as a general policy, we do not disclose no matter what, the law doesn't say that. And I don't think the city attorney says that as a general policy, you should never disclose home addresses or telephone numbers. In fact, I think what the city attorney says is you should not disclose them if they're not relevant to, I think it's on 76. Yes, because the information is unrelated to RPD's performance of its duties. So I think the complainant's issue that he had and why he wanted the information was because he felt that Recs and Parks' duties related to the birthing contract, that they had violated their duties because they had failed to follow the proper waitlist procedure. And his attempt was to get the numbers and get the address information so he could contact those people, so he could follow up on the Rec and Parks department's duties and performance. So that information was actually relevant. And even in the case law that the city attorney cites, starting with, I guess, just the general rule of Braun v. City Taft, it says that public disclosure of a private home address and telephone numbers would violate the privacy rights of the individual seeking the birth assignment because there is no compelling justification in the public interest of the disclosure. He immediately said that this is the compelling public interest in why that information be disclosing. So he's giving reasoning why that information and why he's requesting specifically the telephone addresses and home addresses. So I think in this case, he's met the Braun v. Taft standard. So then you go to the next case law, which would be City of San Jose. And the quote from there is, in determining whether the public interest in non-disclosure of individuals' names and addresses outweighs the public interest in disclosure of that information, courts have evaluated whether disclosure would serve the legislative purpose of shedding light on the agency's performance of its statutory duties. So in fact, the quoting of the case law by the city attorney to help the Rec and Park actually works against them, because he's needing this in order to shed light on an agency's performance of its statutory duties. So I think we should refer to ethics, and I think we should cite back the city attorney's case law and explain why he needed the home addresses and why he needed the telephone records, in particular, in order to determine whether the city and whether the city department had complied with its duties, in which it was required to. And so I think under these circumstances, I do not believe, unlike maybe some other members of the task force, that under all circumstances that the home addresses and names have to be disclosed. I think it should be weighed by a case-by-case basis, and under this case, those names and addresses should have been disclosed. And I think that, and I wish Mr. Warfield and I wish Mr. Hartz were here, because I think if you are going to make a request, a sunshine request, I think it's important that you would like the names and addresses of those individuals not to be redacted, that you should say and request that the names and addresses and telephone numbers not be redacted because of this reason, being that you feel like that those names and addresses will shed light on the acts of the agency. So I think here we have a different case than other case, but I think the just the blanket we don't give out names and addresses is incorrect policy, and I think that policy needs to be changed. And I think we need to kind of have a burden shift that the city attorney itself has requested and analyzed here in their own documents.
Great. Member Pilpel, if we can keep it brief, please, because I think we summed that up.
Yeah, I'm not going to add much to that. I agree with Member Washburn and Member Sims' analysis, which I think well articulated the matter. And I suspect that we're all heading in the same direction, perhaps with one exception over there. But I think that we should include the correspondence with Mr. Ginsburg from Mr. Mayanki in the file.
Yeah.
And if we do refer the matter, I think this needs a carefully worded cover letter to explain not just what our finding or recommendation is, but more of the basis, something about birthing contracts versus waitlist application, that there may be an underlying allegation of jumping the list, and that was one of the reasons for the request. I agree very much with what Member Sims just said, that I'm not prepared to make a broad statement that you always disclose or you always redact. I think there are some broad instances where you always disclose and other instances where you always redact, and a number of other instances like this where it's very case specific. And I think this is very case specific. If we have given, or if sufficient notice was received by Mr. Ginsburg, then I think he needs to be the named party sent over.
He must be, because he's the department head, according to Section 3. So I'd like to definitely address this.
I understand. And if we do send a letter, I think we should send a copy to the city attorney so that they can give due consideration to that, both in terms of the matter before ethics and going forward in terms of the policy and how it's articulated. Can I just ask Ms. Gong to be very clear on the record? Ms. Gong, is she out there somewhere? The letter dated July 29th, you presumably sent it. We don't have a signed copy. Whether you wrote it or someone else wrote it for you, is this a matter that you actually discussed with Mr. Ginsburg personally?
No.
No. Does this letter represent the position of Mr. Ginsburg and the department?
This is the position of the department.
Okay. How was that position determined? Was it determined by Mr. Ginsburg?
I discussed the position. I I discussed this with my supervisor,
And who is that?
and that's Sarah Ballard.
Okay.
So did
Was she
Mr.
given-
Ginsburg see this letter?
Did he see the letter? Let's see.
Ms. Gong, what is Ms. Ballard's official title?
Director of Policy and Planning or something?
I believe Director of Public Policy.
Okay, thanks.
Policy.
So do you know if he saw the letter? That was addressed to him, that was Sunshine and then you
Oh,
responded?
the one that...
The email.
Yes.
From Mr. That's what I was asking.
Yeah.
Okay, thank you.
Do you know if he saw this July 29th letter?
I don't know.
Do you believe that, who do you believe made the determination to not disclose the records, Mr. Ginsburg or Ms. Ballard, unless you want to take responsibility for it?
Well, this is the department's stance.
And who made that determination?
I'm not sure.
They're not sure. You're the custodian of records for the department.
Right.
I believe the Public Records Act actually, and Jerry, maybe you can find it if we need it, is clear that, or Rick, that where there's a determination made not to disclose, it's made by the head of the agency. I remember seeing that somewhere, 6254, something like that. Anyway, are you acknowledging that this is, you're saying that this is the position of the department?
Yes.
Should we hold Mr. Ginsburg responsible for that decision?
It's not for me to say who you hold people responsible for.
Do you believe that Ms. Ballard is charged with making determinations?
She's the Director of Policy.
Do you believe that she's charged with making the final determination on disclosure on public records request, or is that a responsibility that's held and not delegated by the department head? Can you care to comment on that?
It's not me to say.
I understand what you're getting at, but obviously Ms. Gong has answered this in as many ways as she can, and she does not know the answer. So if we could move on, I'd greatly appreciate it.
Okay. Just wanted to have that on the record in case anyone's listening to this in the future.
I feel Mr. Ginsburg, as the head of the department, and Mr. Sims, he is responsible, so it doesn't matter in the underlying.
I just wanted to add also, we're good. You're good.
Thank you.
That I think we also discussed when this matter first came before us that I think a majority of us felt that the application act as a contract or was an attempt to contract with the city, and that even if that you felt that the weight shifting, the burden shifting that you're supposed to do with whether to disclose addresses and names shifted more toward redacting and not non-disclosure, because this was an attempt to contract, kind of similar to what I think we discussed, the bidding process, like a bid, that it made it so that you were not supposed to redact the addresses and then the names and telephone numbers of that contract, kind of like she does with the birthing contract. Because the contracts, you don't have that thing. They don't have the same burden shifting. You just have to disclose the entire contract. So I think maybe that should be put in our letter as well, perhaps.
Through the chair to members of the task force, when a decision of the task force is reduced to writing, it needs to include any findings that you want to be included for the reasoning of that. There is no such finding in this order. So members of the task force may have had a variety of reasons for arriving at the conclusion that they did, but because the specific reason that you're identifying, Member Sims, was not included in the order, then it can't be said that the task force as a body relied on that reason.
Okay.
Yeah.
Sorry, so how can we make additional findings in support? Do we do that now, or do we need to prepare that or delegate that?
It should be done by the task force as a body and voted on in a motion.
Madam Chair?
Okay. Member Nee?
Yeah, I wish Ms. Washburn was still in the room, but
She's nearby.
I know she's here. But perhaps the chair, as a member of the Compliance Amendments Committee, can confirm this recollection of mine. During the Compliance Amendments Committee hearing on this matter, my recollection is that Ms. Gong told us at that hearing that the, notwithstanding the order of determination, the department intended to stick by its policy of not revealing the personal information.
Yes.
So, you know, the order of determination was there, and the Compliance Amendments Committee was told just point blank they were not going to comply.
Exactly. That's what was said. And Ms. Gong has stated that as well. So, Attorney Threet, sorry.
Yes, through the chair to members of the task force, just in order to help make the order as strong as you may wish it, or the referral, the referral for willful failure is for willful failure to fulfill responsibilities under the ordinance. It is not specifically for failure to comply with an order of determination. So the position of the department will be that it has complied with the ordinance, and furthermore that it has done so under the advice of its attorney. So I do believe that a referral under 6734 simply for failing to comply with the order of determination is less likely to be effective than a referral that includes findings of why this behavior by the department violates the ordinance. So it would be helpful to have those findings.
Okay.
Madam Chair?
Member Pilpel?
I'm just thinking that the more we play this out, the longer this is going to take tonight, and maybe the better course would be to either take a vote tonight that we intend to make a referral, if that's in fact our intention, or something like that, and to not take final action tonight, but in the next month for someone, not me, to volunteer to draft some additional language, maybe Member Sims with Member Washburn, to document
What the findings?
Proposed findings. You know, I mean, I think if we just send something over, as Attorney Three suggested, that just says they didn't comply, that's not the thing here, and there's more of a story, and I think we need to tell that in writing and make specific so I'm leaning towards not doing all of that tonight, but doing at least some part that makes that start to happen. And unfortunately, to Mr. Mianki, it's another month, but, I think if we're going to try to make this one stick, it's got to have some stuff on it.
And I'm happy to work with those members to that effect.
Great, thank you. Member Sims, will you
No, I'll help.
Great. So can we say, and would you be amenable to having this done by the next meeting in September?
Yes.
A month? And Member Washburn, you'll work with them to give them, from the compliance, kind of like a record of
Right, yeah, I would hope that as an attorney, Member Sims, who really fleshed out my ill-formed ideas, would take the first crack at this, and then I'm happy to work with you.
And then Attorney Three can guide us.
The other members.
And then I'm going to say, and then I think next week we put it on the agenda to vote on that letter being our official findings of a task force, and then send it to the ethics. Would be my recommendation. Yeah.
I agree. So, yes. So right now, after we've had this discussion, I'd like to invite the respondent up. If you have any final comments or anything you'd like to offer us before. Okay. Any members of the public offer anything additional? No? And Mr. Mianki, if you have any final comments or...
Yes, I agree with Member Pilpil.
Popel, yeah.
To do this right, rather than just, and have more time to get it in the record and well, just what he proposed. I thoroughly agree, and I don't mind coming here another evening or even twice if necessary. Let's get it right, because obviously the city attorney and the Ethics Commission, from what David tells us, is going to rule against you and me. So, let's not give them a reason to do that. Let's write it all down there. That way, if they do disagree, maybe this will solve some of your problems in the future and mine.
Great, thank you. So at this time, I'd like to know if there is a motion to do what you just said. Member Nee?
Madam Chair, I'd like to move that we continue this matter until the September 4th meeting in order to give certain members of the task force time to draft correspondence in a way that will be meaningful to moving this matter toward a successful conclusion.
Second.
I'd just like to see if you could amend it to say the names of the people that are going to, Member Sims and...
That's fine. Member Sims,
So we have on the
Member
record.
Washburn, and Chair and
Great.
City Attorney Threed. And were you in that motion also, Chair Grant?
No.
Okay, just those three then.
Yes, to bring it to us. Okay. So it's been...
To prepare findings and a referral letter, all as a
bring
draft.
back to
and bring it back.
this meeting on September 4th? 4th? Okay, great. Was it seconded?
I seconded it.
Okay,
Public comment.
great. Is there any public comment on this issue? If not, I'll consider the matter, I'm going to close it to public comment. And Madam Clerk, if you could do a roll call vote, greatly appreciate it.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
Aye. You have 8 ayes, 1 no.
Great. So this matter has been continued to the next month's meeting. Thank you both for your participation. I'll see you next month, I'm sure. At this time, I would like to take a 10-minute break. So we'll come back at like 6:20, and then we will hear the next item on the agenda, which will be, what is it? Item number 7. What is it? Yeah, item number 7.
Yeah, exactly.
Continue. Order. 2 notes I'd like to make first. Madam Clerk, did you note that Member Sims and Member Fisher were late because we've marked them as absent before? Okay, cool. And Member David wanted to say something before we started this next portion?
I know that the next case has to deal with the Arts Commission, and I just want to acknowledge the passing away of a famous and San Francisco artist and resident, Ruth Asawa, yesterday, and she was an amazing arts educator, advocate, and public education advocate, and we are all sorry that she's gone, and that we pass along our condolences to the art community and to her family. So,
Thank you so much. Madam Clerk, can you? Oh, I'm sorry. Member Pilpel had 2 things he wanted to make sure we put on the
And I
agenda for next
can't
time.
add
Quickly.
to the Ms. Azawa comment. Well taken, very well taken. With respect to item 4 that we just continued against Rec Park, I guess I just want to be clear that our notice, that the captioned item next time refers to Mr. Ginsburg, and that we notify Mr. Ginsburg and Ms. Ballard as well, because I don't want Ms. Gong to be the person that, falls for that.
Yeah,
Anyway.
that's what we decided, that
Okay,
we were
but-
naming. We can add.
And so that we're sure
Mr.
that we
Ginsburg.
so that we be sure to email both of them.
Madam Clerk she definitely will
Okay.
email them since they're named as parties in it.
Okay. And also on item 6, the Wood Robbins item, there was no city attorney memo in it this time. If we did continue that for 2 months, I'm assuming that there will be a memo at that time. I don't know why there wasn't yet.
Attorney 3, yeah, the question is, yes.
Member Popoff, you're asking why there's not a city attorney memo. It's because both parties asked for continuance.
Okay.
So there will be one when we hear the case.
Cool. Thank you very much.
So, Madam Clerk, will you read the next item on the agenda?
Item number 7, file number 13011, complaint filed by Paula Detesh against the Arts Commission for allegedly not providing documents relating to Evelyn Russell, former Arts Commission Secretary.
Great. So the first item is the issue of jurisdiction. I believe, wait, can you sit down 1 second, please? Give me 1 moment. Hold on 1 second. If you could sit down until we discuss this. This is something that had been brought and continued to this meeting, and jurisdiction had been accepted by both parties last time. So if there is any concern that jurisdiction is not correct, please come forward.
I think, according to the draft minutes, we actually found jurisdiction last time.
Can I
That's what I
talk?
just said, yeah. No, there's an order of things, so just wait 1 second and you will get
I
to
don't think we need to act on 7A.
Great. So the issue of jurisdiction had been agreed upon, which is what I was saying last time. So we don't need to vote on that again. We don't need to contest it again or anything of that sort. So we can get to the matter, substance of the case. So at this time, if you would just step back for 1 second and let us move forward. Okay? So since that had been voted on previously, we don't need to do...
I'm sorry, the heading on this is incorrect. I asked for a copy of the file last week.
Just hold on 1 second. That is when we will get to that issue. This is about jurisdiction, which had been voted on last time. So if you can just sit tight, we greatly appreciate it. So in the matter of jurisdiction, that had been agreed upon. So now we can move to the issue of the substance of the case. And just to remind everybody, we had asked for the, and Madam Clerk, you can remind me, we had asked for the complainant to provide the original documentation for the original complaint that we did not have. If you don't sit down, I'm going to dismiss this. So please just sit down and let us finish this. So at this time, that's the first thing I want to know. Did you ever receive the original documentation?
An email went out on Friday, July 26th to the complainant along with CC to the respondents, Kate Patterson, asking Mr. Tesh, the continuance of your above referenced complaint is being scheduled for August 7th. Please provide an additional pertinent documentation in support of your complaint as requested by a task force on July 9th. Mr. Tesh did not respond. She did come into the office last week, Friday, I believe, to look at her files, but nothing since then has been received by our office that you've requested from the July 9th meeting.
Okay, thank you very much. At this time, I'd like to offer the complainant, which is you. You have 5 minutes to kind of give us an update of the case that you asked to be continued.
This is not the, okay, last week I pulled this case, and the case was stamped in the clerk's office on August 22nd, 2012 at 4:38 p.m. This has nothing to do with Evelyn Russell. This is any documentation regarding Howard Lazar's allegation that I am harassing or stalking a Brianna Smith, police reports, emails, or any documents. This is in the file, page 2. This is the substance of this complaint. Your heading is wrong. I went in several times to look at the file while this was going on. I asked Does this have to do with an Evelyn Russell? What is going on with this file? It is not a continuation of an old file. It is not. That is a case that, for some reason, got confused with this one. This is the document. This is the complaint. It was never even addressed in the file which I copied. And forgive me, this was the first Sunshine request that I filed, and no one really in the clerk's office helps you. You're kind of given a piece of paper and left on your own. And especially if you're from the East Coast where nothing like this exists, you're still left on your own. So I basically included a lot of questions to the custodian of record, Howard Lazar, by email, because they never pick up the phone. They haven't in well over 15 years. Email is a paper trail. I was on the East Coast for 7 years. There was a civil grand jury report, and I expected that things had changed. So I wanted to ask some questions and try and get answers, but of course, even in this paper trail, I never did. So the substance of this complaint was never even addressed. Allegations that I'm harassing somebody called Brianna Smith, who I don't even know. It's been well over 10 days. It's been almost a year. And that's the substance of this complaint.
Are you finished with your statement?
Well, I
You
have 5 minutes.
So if you have anything else to say. And just to be clear, are you saying that this is not the case that you are referring to?
Correct. This was, I don't know if you have it in your records, but I wanted to be sure, and I looked at the case multiple times. This is the substance of this case before you today. No. It was filed before the other one, July 17th. So that's that. This is a lot of emails, which I tried to be clear and specific. I was asking for just simple questions about how you do things, what's your procedure. They're pretty clear. They have numbers. They're pretty clear, simple questions. Most of them weren't answered. They weren't answered in a timely fashion at all. And that's basically it. And that was done at a time when you were waiting for a disability member on your task force. I waited 8 months for this complaint to be heard today.
Okay.
Longer than 8 months.
Okay. I'm just a bit confused with what you're saying.
Well, it's right here.
No, what I'm asking
Go
is
ahead.
this the complaint that we have forth against Howard Lazar and the San Francisco Arts Commission violating the ordinance by failing to timely respond to an IDR regarding Evelyn Russell that we
No.
have before us? This is not what we were here talking about?
No, it's not.
And that's what we continued last month and you asked for.
That's what confused me also. When I walked out of here the last meeting, I was saying to myself, she wants documents from me as to what date, what is it about. So I was leaving messages on the answering machine asking for more information. As of what date? What is this about? Can you give me more information? And that's why I went in and copied the file. And if you recall, I'm sure you don't, last month, I told you regarding the Evelyn Russell matter that this thing died on the floor for a technical reason. I put somebody's email incorrectly, so the person didn't get it. So it was for a technical reason that you accepted jurisdiction on the Evelyn Russell thing, but I never got any documents. Paula Jessen of the city attorney's office went out of her way to mail me stuff, and what it was 6 pages of the Pledge of Allegiance. And I had asked, could the Arts Commission leave these documents that they say that I received in the clerk's office, and they did not.
Okay.
This is the complaint before you today.
Okay. Thank you. Is there anyone here to offer in support of Ms. Tatesh, offer any additional facts and evidence? If not, then I'd like to invite the Arts Commission representative.
Kate Patterson. I'm the Director of Communications for the San Francisco Arts Commission, and I am now very confused. I'm here today with Howard Lazar, and we were here with the presumption that we were going to continue with the agendized item, which was very clearly delineated in the agenda. So I'll just speak to that. I provided you with a history of emails related to this issue, and Howard will go into details regarding requests made for personnel records or information related to Evelyn Russell. And I do recall that when I was here in January, basically it was an almost identical case in which Mr. Tesh had made a number of requests related to Evelyn Russell, that it also kind of moved to this bizarre tangent regarding Brianna Smith and an accusation of harassment of Brianna Smith. And so I just encourage you to review those minutes. So hopefully together we can come to some clarity. I want to point out that in my letter that, and this happens often, that we're accused by Ms. Datesh of not responding in a timely fashion, when in fact she's failed to do her due diligence in ensuring that the email to a staff member is accurate. So we can't be held accountable for emails that we never received and for not responding to those emails. And as I said, we were here in January and basically going over the same correspondence, and at that time this body found that there was no violation. So in summary, Howard's here to go over that correspondence, but I hope that your conclusion is the same as it was in January.
Thank you. Mr. Lazar?
Thank you, members. Howard Lazar, Street Arts Program Director for the Arts Commission. To recall the history of the correspondence with Ms. Datesh, on January 8th of this year, Ms. Osbury wrote to me and said that the task force attorney was prepping for complaint 12032, another complaint. And the attorney wanted to know if the Arts Commission has responded further, specifically to Ms. Datesh's complaint email on July 16th, 2012. And to that inquiry, I responded to Ms. Osbury by saying that and there were three different requests built into Ms. Datesh's request. And I'll only address the first one, dealing with Evelyn Russell, who is a former employee of the Arts Commission. And so what I said to Ms. Osbury was, with respect to the first paragraph containing a request for, quote, all documents relating to former Secretary Evelyn Russell, I responded to Ms. Datesh on August 31st, 2012. With regard to her request concerning Ms. Russell's promotion, I responded to her on August 1st, 2012, and on August 7th, 2012. And I had attached my email responses to Ms. Datesh in this response to Ms. Osbury. And I have it here. I'm not going to read the whole thing to you, obviously, but basically, on August 1st, I said to Ms. Datesh in our letter, we are furnishing you with copies of personnel records pertaining Evelyn Russell, including records relating to a job promotion in which Ms. Russell was promoted from a secretary to curator 1. Note that we have redacted information that is exempt from disclosure because it contains personnel information, the disclosure of which would constitute an unwarranted invasion of personal privacy, etc., etc. Then we, on August 7th, I wrote back to Ms. Datesh and I said, please see the attached PDF file of copies of personnel records pertaining to Evelyn Russell, including records relating to a job promotion in which Ms. Russell was promoted from secretary to curator 1. And again, note we've redacted information. And then finally, I guess, sorry, that might have been it. Oh, yes. the August 31st letter to Ms. Dadish, I said to her, in your request, you ask, I request the date of Evelyn Russell, a former secretary with the SFAC, was no longer employed by that department. In response, the date of which Ms. Russell was no longer employed by the Arts Commission was February 8th, 2010. May I continue, or I just heard the timer go off?
Yeah. I think we're very familiar with this.
Okay.
So you don't need to go on,
Okay.
but I do get the gist, because this is where we're last.
I just want to tell you that...
You can finish up, definitely, just finish up your sentence.
My point is, I fully responded on numerous occasions to this request and furnished the evidence for that.
Thank you very much. And you will have a rebuttal and conclusion as well. Okay, thank you. Is there anyone here to offer any support of facts and evidence for the respondent? If not, I'd like to open it up to the task force members for any questions they might have for either the complainant or the respondent. Member David.
Ms. Daytesh. Yes. I want to try to clarify a couple of things. Are you saying that you never filed a sunshine complaint for against the Arts Commission for records regarding Evelyn Russell?
I did file a complaint, and it died on the floor. You accepted jurisdiction, but for a technical, it was the first sunshine complaint I filed. And again, when you walk into the clerk's office, they don't help you at all. And it died on the floor because I put somebody's email address wrong, and Member Sims caught that. So it died on the floor.
So from your point of view, are we hearing, this is the second time we're hearing this particular case?
No.
From your point of view?
No, from my point of view, no. And that's where I became confused, because you wanted me, as of a certain date, to go back and look at emails and furnish them today in front of the task force. And on walking out, I said, again, I never got any documents on that case. Can these people leave them at the clerk's office? There are multiple emails from Paula Jessen where she's communicating with Howard Lazar, saying, Lazar is telling me that your email address is wrong, or that you have multiple emails. Is that
Ms.
true?
Daytesh, I'm sorry.
Go ahead.
I really want to I want to get one thing figured out first.
Okay.
So the first thing I want to get figured out is that, is your sunshine request, your case dealing with Evelyn Russell, has that been dealt with?
It's been dealt with, and my understanding, the rules of the task force are, once an issue is either dismissed or closed, that very same issue cannot be brought through the task force again, and that's not why we're here today.
Gotcha. Okay, so you, from your point of view, the Evelyn Russell case was dealt with. It's over, and what you're confused about is that you believe that you are coming here tonight to deal with a different case.
I know that for a fact because, again, I looked at the file. It's stamped in the clerk's office. It's very clear. It's very straightforward, and it was never addressed. It's page 2 of the very same file.
Can you pass that?
Yes.
Yeah.
Can I, Member Pilpel?
Let me try it as well. I'm looking at our complaint log. That indicates that July 9th, on or about July 9th, you filed a complaint, 12-032. That was heard on January 16th of this year. Due to lack of a motion, the task force found no violation. It's on our draft minutes that are up for discussion shortly. I was not at that meeting, but that's what I understand occurred. The very next day, January 17th, we have a clocked-in complaint, 13011, that refers, that's on page 375 of our packet, that says in the alleged violation, sent an immediate disclosure request, subject heading, email to Howard Lazar at SF.gov, requesting all documents related to Evelyn Russell, former employee. Over 10 days have passed with no response. That was clocked in on January 17th and assigned file number 13011. That's the item that is calendared tonight before us. I think that's the only thing that we could take action on. It appears that the items that we were provided in connection with that file are remarkably similar to the 12032 file. And I'm interested in looking at what members David over there are having fun with. Oh, here it comes.
CA3, did you have
That's the
something?
same. Okay, this is the same document that I was referring to, so that's cool.
The other side.
So this, just for the record, so this is a document that is dated August 22nd, 2012. This is different than what was in our different than what is in our packet.
The case number?
This does not seem to have a case number. This says Arts Commission, name of individual, contact the Department of the Commission, Howard Lazar, Sunshine Ordinance Section 67C, and it's asking for any documentation regarding Howard Lazar's allegation that I am harassing, and I just can't, the person's name, Smith, police, email, and I'm happy to pass it around. And this is dated August 22nd, 2012. Yeah.
What file did that come from?
It came from the file.
No, we're asking.
Okay.
Oh, this is from August 22nd, 2012.
That's right.
So this is from last year. Okay. So is this the case we should be hearing?
It was in the file, and that's what I thought what was being heard today.
What file did it come from?
So, through the chair, I don't have an answer to that question, but I would note that when I've received information supporting complaints that relate, supporting information related to complaints that Ms. Datesh has filed, it's often difficult to discern exactly what the request is and what the complaint is. There's often multiple emails that don't necessarily relate to the exact complaint. I've had a difficulty figuring out what things are. In regard to this complaint, this is the complaint that it was before the task force last month. This is the complaint that was heard by the task force last month, with Ms. Datesh not contesting that it was a wrong thing last month. And this is the complaint that was continued to this month for further hearing and for Ms. Datesh to provide any other information she wanted to provide to support the complaint. It's a little disconcerting to now hear the complainant state that it's not the right complaint. It's a completely different one that's not in this file.
According to your own rules, once a motion is made or not made and the case is closed, it cannot be reheard. That's why I was confused. When I walked out of here last month, I was saying to myself, what documents is she talking about? The case is closed. Member Sims, you said the email address was wrong.
Well, I mean,
how can you reopen a case that was closed? That was in the file. That was never heard. And my apologies. Again, it's only through time and through trial and error that you understand how to file complaints, how to write things, how to ask specific questions. It's only by sitting here that you learn these things. The clerk's office is really not helpful in that. This was the first complaint I filed. And owing to the fact that these people are not picking up the phone, they're not responding to emails, they leave you hanging for weeks at a time. That particular thing was when the guy picked up the phone, screamed something, and slammed it down. And I heard the name Brian or Brianna Smith, and I'm saying to myself, I'd like information.
Mr. Tesh.
Yes.
I think we all are a little confused, but
yeah.
I think what we need to deal with is with what all we can deal with under our sunshine laws actually are the case that is been docketed and has been agendized. So what we have agendized is the complaint that was received on 1/17/2013, file number 13011, that we discussed last month, that we are here discussing again this month, and we were hoping to find, I guess, these emails from June 28th or that you were supposed to provide to us, or June 24th and 28th, that you were supposed to provide to us. I don't think that you have provided those to us at this point. Maybe someone else can, if has time, can go back and see when Mrs. Detesh's other complaint and what that was in regards to, that I guess noticed that there was some email address issues for. I'm trying to look back here and see if I can find the maybe what complaint that was.
Okay.
I maybe the 7/9/2012 complaint you're thinking of, which was 12032. I think perhaps, Mr. Tesh, you might have just filed more complaints than, or may have a memory lapse into filing of this complaint, or you may have filed several complaints regarding the same issues.
No. I'm sorry, but...
No, Mr. Tesh, I really honestly believe you might have filed multiple complaints regarding the same issues or like issues or similar issues, and you're allowed to make as many sunshine requests as you can under the law, but we kind of have to hear what's before us, and I think our clerk should look into why this 8/22/2012 complaint has not been heard or has not been resolved, and we should go forward with that after this meeting. But when it comes in regards to this complaint before us today, I don't see any more evidence for us to move forward to finding, at least from my perspective, finding a violation.
Exactly. That's what we had continued for this month. You were going to bring us the additional documentation. This that you provided us, let me just clarify, because I do think that there are a lot of complaints from you. You listen for 1 second, please. 12032, this is from something that was, I have to get my glasses, a matter that was concluded on January 16th, from July 9th, 2012, Task Force, January 16th, 13th. Due to a lack of motion, the Task Force, we found no violation. This matter was concluded.
And
this particular thing that you just submitted.
That is the Evelyn Russell matter, ma'am. It is the same complaint. Pull it up.
No.
Yes,
we
it
are
is.
pulling up. So
pull up that complaint.
It was. I think what she's trying to say, Ms. Detesh, is that we ruled on it on January 16th, and then you filed a new complaint on January 17th, which is what we are here tonight talking about. That's what is stamped on our records. That's why we're confused. That's what it looks like, that on the 16th of January. Am I? You're correct. On the 16th of January, we resolved this issue, and then on the 17th of January, you filed the same complaint. That's why.
Okay, can we get to the heart of the matter here? Is what I've been trying to tell you in a very clear, straightforward manner. If anyone, a member of the public, goes to the clerk's office and asks questions about the Sunshine Task Force, you're going to get a voicemail. Maybe if Ms. Osbury doesn't have time, has a few minutes, and you have a specific question, she might help you. But if you're just generally asking questions, it comes by trial and error. It's only by sitting here. You might have somebody helping you write these complaints. But in this Evelyn Russell matter, the matter was concluded. It was a case, I didn't receive the documents for technical reasons. It died on the floor. It's a mistake. If you're talking about that I went into the clerk's office and filed a piece of paper and they stamped it, well, maybe she should have reviewed it and said, this is a matter that's died on the floor. This is part of our rules.
Okay.
Instead, I'm here forever thinking I'm on a different matter entirely that was never addressed at all.
Okay, Madam Clerk, do you have something you'd like to comment on?
Yes, I'm sorry. Through the chair and to the members. Mr. Tesh, you do call every day.
I'm not calling anymore.
You call every day. You're in the office every day, and I do
Asking
help
questions,
you. Right,
if
and
you
I
can,
am up
if
front.
you have time.
I do go up front to help you, just like I did on Friday, to pull these documents in which you weren't clear as to what the task force was asking you. And you pulled the document that you circulated just now from last year, a case that we already heard.
It was in the file. That's what I thought we were here for. No. And then you continue to say, well, file a complaint, file a complaint. Because the full commission didn't meet on Monday, and
Mr. Tesh, point of order, why don't we let Madam Clerk finish explaining what occurred in her eyes, and then we can move forward.
I asked
one after another. Ms. Clerk, Madam Clerk, do you have something you want to say? And finish it. And please don't interrupt her.
You specifically came in the office asking about the item that was before the task force last month, which is the item that you're before us now. So you were very clear as to what you were coming in there for. So I don't understand. Plus, an email was sent to you.
Firstly, when I walked out of here last month, I was saying to myself, I'm supposed to supply documents. I'm not really clear what they are.
But why didn't you ask us at that time, then, if you were having a concern about the documents?
I went to the clerk's office the next day, and I left voicemails. I did not get a message. Then I went back because I understood they were going to leave the documents in the clerk's office. I did not get anything, and in the emails from Paula Jessen, it's always resistance from these people. It came back. She has different emails. It's all this kind of nonsense that is just resistance on their part.
Okay.
The Evelyn Russell thing is a dead case, and to leave a case open that's already died on the floor, for what reason, I have no idea, to leave the burden on me, and it's not clear, for me to continue to go back to the clerk's office to ask what documents is she talking about, what does she want, it's just strange altogether.
Okay. Attorney Threed?
Just as a point of procedure, to remind the task force, any complainant is free to withdraw a complaint at any point that they think is no longer necessary to move forward. And Ms. Tesh herself has on a number of occasions withdrawn complaints, so she's familiar with that procedure.
Great. Thank you.
I ask questions.
Okay. I think we're good.
So this was just basically a waste of time on everybody's part.
Great. Thank you.
So
Member Popo?
I think if I understand correctly, the Evelyn Russell matter is not going to be heard. If there was confusion about what was da-da-da, then perhaps we should see if there's any further public comment. Take no action on 1311. Let it go away. And if Ms. Tesh wants to refile concern about whoever, whatever, she's free to do that. And we'll start over from scratch and not hear this, because she's saying that either it's already been heard and adjudicated, or it wasn't properly whatever.
It wasn't
and the only
headed
thing, excuse me, and the only thing that we can act on is what's on the
Before
agenda
us.
tonight.
And what's the agenda?
Okay,
That's
can
what I
I
was
have 3 minutes?
Okay. Yes, you may. I'm going to get, but you would be secondary. Would Mr. Lazar or Ms. Patterson care to offer concluding remarks or kind of any last statement? Can you please sit down until your moment? Thank you very much.
Welcome to our world. It is like a constant Groundhog's Day with regard to Ms. Tesh and her many complaints and requests, which are confused and intersect all the time. It takes me a lot of time to research this correspondence and to come up with a coherent letter that summarizes it for you. The fact that we're here basically repeating something that we did in January is very disheartening. She's very savvy. She absolutely knows the process. We've all been to the rodeo together multiple times, and I just find it, I don't think that this body should legitimize this kind of behavior. I think that there is significant taxpayer dollars with regard to our time, and it's just wrong. And we have demonstrated over and over again that we, despite the confusion and the repetition, we have responded in a timely and cordial fashion in every instance. So I thank you I hope you conclude the same way you did in January. We appreciate it, and yes, that's all. Thanks.
Thank you. Mr. Tesh? You have 3 minutes.
If I could pick out a typical example. These people have many, many violations. It has nothing to do with me. This is the second time I've been here. Every meeting has violations, problems. For example, this is normal. There was a full commission meeting this past Monday, room 416. It appears well into 72 hours on their website. So unless you know it's first Monday of the month and you're scanning, you don't really know what's going on. But both myself and a friend who took a day off from work stood in front of that door at the meeting time. We stood there for an hour. The doors did not open. There was no meeting posted to the left of the door, and there was no notice of a cancellation. My friend took a day off. She actually went over to the Arts Commission offices, and I do not go in there. I believe she made the mistake of walking into the back. There are no cameras, there's no signs, there was nobody in this waiting area. And then I got an email with a bunch of lies, that the meeting was canceled and I posted it there, and there was somebody at the front desk. There are no cameras, there was no notice. These are all meeting violations. These are sunshine violations. So, and it's not like I call every day, it's that I'm somewhat interested. So I asked the clerk, well, what do I do? Well, file a complaint, file a complaint, file a complaint. Oh my God, my life would revolve around policing meetings with these people. I don't have the time. They've been making mistakes for 41 years. It's my mistake to take my time out to go to a meeting, because the meetings don't post, the minutes don't post correctly. There are always problems. You're never notified of a cancellation, and they're clear violations. It's only over time that you know these things, and you know how to write these complaints, and you know how to present them in a normal way. But you have to understand, I'm not from California. We don't have these mechanisms. And if you're walking into a clerk's office and they're stamping something in, well, you believe that that's what's going to be heard that day.
Thank you.
Okay.
At this time,
One Commissioner Chu was actually in the cafe basement sleeping. They didn't even bother to notify him on Monday. Thank you.
Okay. Thank you. At this time, I'd like to know if there is anyone here that would like to find a violation of the Sunshine Ordinance based upon what you heard tonight? No? I'm going to do that next. If not, is there any public comment on this? Is there anyone there? I can't see. Then, if there is not, I'm going to declare this matter concluded. Mr. Tesh, you are more than welcome to file a complaint, another complaint if you'd like to. No, there's no comment. I just wanted to let you know that, though. So.
People can learn how to write these things, because it wastes your time, it wastes my time, it's not productive.
Madam Clerk, is there a workshop? No, they just go through the process.
There's a good government guide, city attorney.
Why don't you listen to her answer that she's helping you with right now?
I'll email you the information, but there is a workshop. I think the city attorney's office puts on a sunshine workshop, so I can let you know about that.
Great, thank you. Thank you all for coming tonight. Have a good night. Madam Clerk, can you go to the next item on the agenda? Thank you very much. Matters concluded. Did I say that?
Patterson?
Without objection?
The matter is concluded without objection.
Ms. Patterson?
No action taken. Matters concluded. Thank you.
Item number 9, approval of minutes from January 16, 2013.
No, I know. Attorney Threet, do we need him?
I just wanted to inquire whether anyone needed anything before I departed this evening.
Just a quick preview. I was going to hand out copies of the Tim Cruz versus Willows Unified School District decision. I thought that would be of interest to the task force.
What is that about?
Are you familiar with it?
What's that for?
Just an appellate decision of interest that talked about CDs, PDF of documents.
Oh, okay.
And whether a document request was frivolous for purpose of an attorney fee motion.
Okay.
It was, got some publicity.
Through the chair, I'm not familiar with this case, so I appreciate receiving it.
Perfect.
And it was argued by Carl Olson, a former member of this task force.
Oh, okay, great. So we'll take that at the end, take that home for reading.
And just also FYI to Attorney Threet, there was another case that I didn't make copies of that was in a land use context and didn't really discuss public records at great length, but talked about the common interest doctrine and when that's applicable. I can give you the site on that later if you're interested. Anyway, it didn't have
Thank you.
as much interest.
Okay, so you made copies for everybody, we can take them home for our reading.
Yes.
Thank you.
If you're having troubles. Yes.
Yes.
As to the minutes, weren't we on the minutes?
Yes.
Okay, so I have markups to the January minutes. I'm good with them. There was one thing. No. Okay, so January.
January's good
I'm
for
good
you?
with, so I will move to approve the January minutes as corrected.
Do I have a second?
Second.
Any
Thanks.
conversation? Anyone have any other amendments? Thank you, Attorney Threet. Have a good night. I'm like Madam Washburn. Or Washburn.
Yeah, Madame sounds great. I believe I've given Ms. Osbury all of my little edits for most of these, but didn't we have a discussion about our desire to have the timestamps on the minutes?
Madam Chair?
Member Nee?
Yeah, I believe we had that discussion at our July or June meeting, and I don't recall which, but I think the decision at that time was that it would be really too onerous to ask Ms. Osbury to go back and do timestamps for all the sets of minutes before us. However, I believe we did ask that from that time forward, the minutes be timestamped.
Madam Clerk, do you remember what we decided on that? Or I do remember the being onerous part, so I don't remember. I do remember that.
Right. No, there was discussion regarding timestamps, and like Mr. Nee conveyed, that it would be too time-consuming to go back to listen. You're talking about setting 8 hours. Moving forward, there was discussion, but there was never a motion in place
That's what I thought.
to be done.
Okay. So can you refresh my memory? We said that we would timestamp the minutes, so what was decided?
Well, the timestamp would be per item on each set of minutes.
Okay. Okay.
And I don't believe a motion on that is necessary. I believe a directive from the chair would suffice.
Okay. I'd love to get everyone's input. For me, I do know the amount of work that Madam Clerk does, and it can become very, very time-consuming to do that, and you can correct me. I'd love to leave this up to Madam Clerk to tell me what, you can or can't do. You have a lot of stuff going on. Is it hard to do this during the meeting? It seems to keep. So we were asking her to each item to have it like at 3:05 the meeting started. At 3:15 we start. So just that, or
Yes.
We heard this motion at 4:20.
Well,
Yeah.
no, not, I mean, just the time, the start and end time for each item on an agenda.
Okay.
On a set of minutes. And this was done routinely by Ms. Osbury's predecessor, Chris Rustum.
Is it done in other,
No, not that I know of. I'm not that I know of. So I've looked at a lot of other minutes. The thing is that he's talking, so I remember he was talking about the counters, just looking at the counter each time an item is called. But then also, once the audio is compressed, because you go into recess, you got to compress the items, the counter will not match the counter as it is uploaded. So it'll be two different counters, if that makes sense.
so it won't be accurate?
It won't be accurate anyway.
Well, I'm wondering if there's a way of, would it even approximate time so that members of the public looking through a set of minutes and wanting to listen to an item to get the kind of detail that is absent from the minutes, is there even a possible approximation?
It'll be approximation on the counter time, but again, that will be off, because you're talking about taking this audio, it's compressed, it's put in different formats, then IT uploads it, so it's a different counter. So I don't know how accurate it would be.
Okay, I'd like to see if we can get with the IT people and see if we can iron that out.
Okay, because as of now...
Again, the minutes are there for the public. And San Francisco has a population of upward of 800,000 people, and not all of them can attend the task force meetings. So, those who are interested in what we do, we need to make it as easy as possible for them to be able to trace our actions and the reasons therefore.
No, I agree with that, but I do understand what you're saying, too. If it's not, because we're going to set ourselves up with members of the public, if the time does not correspond to what was happening, we're going to get in trouble. So maybe that is something we can bring up with the IT department, whoever handles that, and let's see what they tell us. So let's just leave it at that right now. I think that's to make a start and see how we can amend that issue. But as of now, because I do, once we start putting up times and they aren't the right times, the members of the public are going to jump right on that and we're doing the wrong thing. So I'd love to see if IT can help us with that.
Right. I think if we have a note saying that these are approximate, but they're not only important just for the public, it's also important to members of the task force who want to go back and listen to something. And I was around when we had more detailed minutes. It was really helpful to all of us when we're trying to remember what happened. It saved us time in the meetings from trying to reconstruct everything. So I really think this is an important matter, and I think that our task force should do the best job we can at making our minutes informative, and this will help.
Okay.
Should we not reach back to our previous?
Right. Now, I'm not negating the importance of it.
Yeah.
It's just that if you want a counter time on, you want it to be accurate, even as an approximate, it may be like a couple of minutes off. And it is a courtesy, as other commissions and task force and boards do not have that counter on. It's a courtesy. So if you want to do it, it has to be as accurate as possible. I will talk to IT to see, but I know it'll be off.
So
Member Philpo?
I would just weigh in to say I think the written minutes should cover the actions taken and whatever commentary we desire to include, which is roughly what we're doing now. I think if there's a way for the linked audio to key in based on the time, which SFG TV does for the video that's available for meetings. So when you click on item 37 of the board, right, it goes to that portion of the video where there was a stamp without including the specific time in the minutes. It's just keyed to that. So maybe there's a way to do that so that everyone's interests are served without getting too...
Jackie.
Yeah. But in any event, we still have a motion before us.
Maybe the answer is to get our meetings telecast.
Well, that has other implications.
Yeah, well, we've been trying for years to get it done. And, we're a sunshine ordinance task force, and for the city to, let's not go into that right now.
And Mr. Chafee's Bill of Rights reminded me of my first term of service on the task force in the late 90s since I replaced Landis Whistler. So.
Okay. So we have a motion, and it was seconded, correct? Yeah. So is there anyone else that had any more comments for the January 16th meeting minutes, or any additions or corrections? And as usual, I'd love to try to have them sent to in advance to Madam Clerk so that we can she's kind of up to date. If not, is there any public comment? No one's here?
Can we run around to the front?
No. If there are no concerns, I'd like to move that we accept these minutes without objection. Okay. Great.
Item number 10, approval of minutes from February 6, 2013, regular meeting.
Again, I will move to adopt with written corrections.
I will second.
It's been moved and seconded. Are there any comments or corrections from the task force?
I think the big thing that I caught on here, the motion to excuse at the beginning, the absent members aren't actually excused until they've been excused. So they're first absent, and then once excused, then they become excused. That was so much fun, let me tell you. There was some other thing that was interesting here.
But did you provide that to Madam Clerk?
No, I'm about to.
Oh, you're going to give it to her?
Yeah.
Okay.
Otherwise, they're non-substantive.
Okay. Does anyone have any other comments or anything?
Let's just state for the record that the public is absent. There's no one in the public seating, so that if someone does come in, we could call for public comment again. But until someone walks in.
Great, thank you.
There is no public. There is no public.
Great, thank you.
I just kept hearing none, moving on.
Yeah.
Hearing none, moving on.
I also want to make clear I retained the 150-word statement as was provided, but I changed the discussion of it. It seemed that it was a little too redundant in how it was described, but the actual comment is absolutely there.
Okay.
So, I mean, it kind of says in three different places, this was provided, this was provided, this was
Okay.
It's provided, and who provided it, it's all there.
Great, okay. So you'll provide that to Madam Clerk, your comments?
Being provided.
Great.
See,
So you can do that.
never mind.
So it has been moved and seconded, and Bryony Jackson, I'd like to see this, to move that we, I'm so tired, pass this motion without objection. Great. Madam Clerk, can we go to the next item?
Item number 11, approval of minutes from the March 6, 2013 regular meeting.
And for this set, I did some of the changes. There's still some more research I need to do. The public comment item didn't have a number, and I think that affects the numbering throughout, and I need to check on Member Nee's recusal and how that gets handled. So I've got some interim changes that I would like to have reflected in the next version, but these I'm not proposing to adopt tonight. It needs some more work.
Okay, so you don't feel that we can...
Right, but I would like those changes to be made for next time. But we're getting there. It's very close.
Okay. So let's just continue.
That's fine.
So you need you to move.
So move
Yeah.
to continue.
Yeah.
So perhaps a motion to continue 11 through 15?
Because you have not had
I haven't done
opportunity
the
to look
others.
at that. Did anyone else have any other cool. So can I get a motion on the floor? Oh, Member Need, would you amend it to continue items number 11 through 15 until...
Certainly.
Thank you. Do I have a second?
Second.
If there is no objection, I'd like to move that we continue items 11 through 15 to next month's meeting, September 4th. Okay, Madam Clerk, will you give me the next item, please?
Item number 16, report compliance and amendments committee meeting from July 16, 2013.
Let's see, we heard the matter that was referred to us earlier this evening, Mr. Mianki against the Rec and Park, and that was about it.
Great, thank you. Madam Clerk, item number
17, I'm sorry. Item number 17, Administrator's Report. Before you should have a copy of the Administrator's Report. In it, outlining requests from community persons, the complaint log, communications received, and mediation of complaints, and that there are 20 complaints currently in the pipeline.
So we have 20? It's good.
Yeah.
It's growing, but it was getting smaller, and now it's, okay, 20, so it's not that bad. Okay.
How do we know which ones are going to be next month? Or is it?
Because we finished, we went up to item number, no, it's in order. It's not a Wheel of Fortune, it's an order that they're received, and so the last one we heard tonight was, what was it?
Well, we pushed
Whatever. So, yeah, you have to continue. So that was 1311.
So 16, I wasn't.
He withdrew it.
He withdrew it.
Yes.
Gone, so we're up to 17.
Yes. And then we'll add,
The
yeah.
Park family.
Okay. So, yeah, so those are the next 5 you can kind of anticipate. Madam?
I'm sorry, can you also clarify the Glad Tidings Church item from last time? That was continued to tonight and didn't appear. Is that what happened there?
That, what was?
It was withdrawn.
Withdrawn, yeah.
So, can I ask a question?
Very nice.
Sure.
Thank you.
So,
I
Madam Clerk, I have a question here. So, looking at your list then, if it says complaint withdrawn, like the one we had today, it goes away. If it says not satisfied with response TBD, meaning that gets scheduled, right?
Mm-hmm.
And then if it says closed, you were the goddess of sunshine and you closed it and solved it?
You as a committee or task force decided to close.
We never even heard it. 13018, Larry Bush. Oh, complainant has not responded, so they don't respond.
That's why it's closed.
Then what does it look like when you mediate it and everybody joins hands and sisterhood and hums and walks away happy?
Then it's withdrawn.
Then it's just withdrawn, okay.
or resolved.
Or found no violation.
Madam Clerk, next item.
Item number 18, announcements, comments, question, future agenda items.
Okay. So I think one of my first comments is our next meeting is September 4th. Is that right after Labor Day?
Yes?
Yeah.
Is that going to be any concerns or issues for anyone, like
Shouldn't
not
be.
being here? Okay.
Wednesday?
It's Labor Day weekend, so it's a Wednesday, though, so, okay. So just keep that in mind. So if you guys have any issues, let me know about that.
The night before my birthday.
Say it again?
The night before.
And we will have our compliance meeting on the 20th. I mean, is that right? Yeah. So that's right. And then, Member Pilpel?
I was going to mention that.
Yeah, if you could mention about your...
We did not have an EOT meeting in July. I am intending to meet in August, but I'm going to have to move that date so that we're giving the complainants and respondents sufficient time.
Okay.
So that we're not crunching that to 3 days. So it's not going to be this coming Monday, but it's going to be sometime in the next couple of weeks. I will
So
check
we'll
with the
be in
members.
August.
That's my intent.
Okay,
Yes.
that's very
gotta happen.
important to me.
Yes.
Thank you.
And I've just passed out the cruise decision.
Oh, perfect.
Take one, pass it on.
Thank you. Is there anything anyone else, I'm sorry, Member,
Can we talk about nominations right now, or is that considered, that's
we can't.
considered, we can't, so that's considered untoward?
But what I will say about nominations, if anyone has any interest in either of the positions, please, come forth next month.
So they can't come forth next
So, no, because it's not an agenda item,
So
so
we
no.
can't-
No,
we can't
no,
do it under
no,
discussions?
No, it's not. So,
That's why I asked if it's untoward or not.
I don't think you could pay any of us to, never mind.
Exactly. So if there's any other agenda items that you want me to put on the agenda for next time, We're good, I think, because we're going to put the letter, Member Washburn and Member Sims have agreed to work on. Member Sims and Member Washburn. So, all that. If not, then can I?
We'll try to do that in 5 or 6 cases, and so we're working.
So next month, we're going to try to get to the 5. We do that every time to try to get 5 or 6 cases, but then what happens, people withdraw, continue, as you know, and then once it's filed, we can't change the agenda. So if there's anything else you want to say? Okay, cool. If there are no other items or future agenda items, I'd love to see someone give me a motion to adjourn this meeting.
Without objection. So move.
Say again.
So move.
Thank you. Is there a second?
Second.
Great. It's been moved and seconded without objection. I'd like to adjourn the August meeting of the Sunshine Task Force. Thank you so much. I know. Let's do this. I know. Let's do this.